Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How are you guys doing? How are you doing today? I hope you're all having a good day. Mine is adequate, I guess. Oh, excuse me. Oh my gosh, I'm starting yawning already. Where is my drink? Oh, this is going to be a bad night. I apparently don't have my non-alcoholic beverage. So that's great. You know. We'll have to remedy that in a little bit. Worst day ever. Oh my gosh. Let's see. Oh my goodness. Oh my goodness. Already with the hate chats, I've been dealing with hatred all day. And frankly, it's a little uncalled for coming from some really fat people, okay? And they're really fat, I guess. But yeah. So anyway, that has been happening today. That's okay. That's a side story. Tonight we're going to cover the closing arguments of Chauvin's attorney. Now, this is the opposite. This is the opposite of the order that they do it. Now, they do this in this way. They don't want to give the prosecution the last word. They don't want to do that because that might be unfair to a defendant. So they give the defense attorney the last word. But today we're not gonna start with the prosecution's closing arguments. We're gonna do the defense's first because we're not the jury. So it doesn't really matter that they get the last word in for us in this way. I want to go ahead and get through the defense attorney's arguments first because I want those to happen before we see the verdict. Derek Chauvin has the presumption of innocence. And to me, it's more interesting to hear the defenses than it is to hear the prosecution's case. We may do the prosecution's case tomorrow. We may do something else. We'll figure it out. But tonight we're going to go through the defense's case. And it's important to remember, as I said in my other video today, it's about raising doubt that is reasonable, not about raising any doubt. Some doubt is not reasonable doubt, and not all doubt is reasonable, and all of that stuff. So that's what we're going to be looking for today in the closing argument. Now, of course, they saw a lot of facts and heard a lot of testimony and all of that during the actual case. And so that will be informing it. But this closing argument is a nice summary, reminder, wrap up of where the defense wants the jury's minds to be. This is the last thing the jury hears before they go into their deliberations. And so that is what we're going to go for. Now, I know, oh my God, I know some stuff happened after the jury left the room. For example, the defense attorney, Eric Nelson, moved for a mistrial based on some things that have happened both inside and outside the courtroom. That move for a mistrial was denied. The judge made a very hyperbolic statement about how, he could have it on appeal, blah, 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 blah. Well, look, if the judge thought the statements were bad enough to declare a mistrial prior to, then he would have done it today. He doesn't think so. He's leaving him, obviously, room for appeal, but he didn't need the judge to do that. It's weird statements coming from the judge. The judge, throughout the trial, has made some statements where he gets mad and he demands better of the prosecution and stuff like that, but doesn't really do anything about it. So at the end of the day, that's all well and great, but he's not actually doing that. But that being said, We'll see. He may not need a mistrial. He may go ahead and be acquitted. And that might be part of the judge's thoughts, is if he gets an acquittal or a hung jury, then the mistrial isn't really that important, because they would have to either the charges would be dismissed, or if it were a mistrial, they would be able to refile the charges and do a new trial. If that happens, but we'll figure this out as we go. We'll figure it out as we go. I don't think people should get their hopes up for anything like that happening. I've also seen people suggesting that the judge is going to rule for a judgment notwithstanding of the verdict, a J&OV, and I think that's very unlikely as well. That's where the judge overturns the jury's decision for a guilty verdict and says, no, there's not sufficient evidence for you to find him guilty, so he's not guilty. That's not going to happen most likely in this case either. So we'll see how that goes. But the stuff that happened outside the case with Maxine Waters, we'll have to see if that's enough. So we'll start that in just a minute. If I could stop yawning, that would be a wonderful, wonderful thing. That said, brief recap. If you don't know, I was down in Georgia over the weekend, paid a visit to Mr. Vic Mignogna and the Neutral Zone Studios. That is where the Star Trek Continues set is, and where you can visit it. They do fan weekends once a month until the summer. So they have one coming up in May, but they will not have any for June, July, August, because it is in Georgia and it is miserably hot there in those months. But then they will be back for the fall and the winter. It was a cool place. Very neat to see all of the work that they did. Got to spend some time with Vic, of course, and got to meet the cast and crew, I guess, of Neutral Zone Studios, the people who keep the building on. It was very cool. Also, Vic did inform me that he has something like 15 events lined up so far this year. And so, I'll be talking about those as I figure out exactly what they are. The one I know about for sure is Matsuri, of course, which will be in July, and I should be at Matsuri as well. So hopefully, if you guys are so inclined, you will come visit me at Anime Matsuri and visit, I guess, Vic too, or something ridiculous. But come visit me, because I'm more fun. Anyway, I did have a very good time down in Georgia. Lady Rackets came with me. If you're a member of the Locals page, you probably got to see a couple of the pictures from that trip. With that, one more thing. While we were down there, Lady Rackets and I like to go to antique shops. More appropriately, Lady Rackets likes to go to antique shops, and I walk around with her, and I occasionally pick something out for myself. What I bought was this. This is a book. It was published in 1945. This is printed in 1945, and it's called The Male Hormone. Skimming it seems pretty funny. So I'm probably going to be reading chapters of it in audiobook format on the Locals page soon. I want to start it in the next day or two here, start recording the first chapter. So that'll be a fun thing coming up. It is a commentary about how testosterone helps weak, sad men become real men. And I'm not even kidding. That's what it is. Talking about these pathetic little babies getting made fun of and being unable to do anything with their lives until they get the miracle of testosterone. It's awesome. It's so funny. So I'm going to do that soon. It should be good. It should be good. So, okay. Do I or Lady Rackets collect any type of antique? She likes cup and saucers. They don't have to particularly be antiques. She just likes cups and saucers, teacups and stuff. Oh, is the camera out of focus? I'll fix it. Yeah, she just like, oh God, why is it so terribly unfocused? There, that's better. She likes teacups and saucers. I don't know why. It's a weird thing, but that's what she likes. I just walk around looking for old funny books. Okay, that being said, Mega Mobass says, Nick, you redacted boomer. Why you hate Ralph? Not that Ralph, the other Ralph, the one in your Discord. Move your nose slightly to the side so you can read your screen and read his Discord DM. P.S. Late and Thunder Thimble. I haven't been on Discord today or yesterday as I was traveling, so I apologize. I'll get back to you. Robert Hubert says, Nick, can you play for the chat the Wombo video I sent to you in your DM? I doubt it. The gray one says, hey, Nick, hope you've been good. I saw some of the final remarks of the prosecution. Correct me if it's wrong, but are you allowed to not only misrepresent facts in closing, but outright lie? I assume you mean lie about the order of events. Pissed me off. Misrepresenting facts is one way to put it. The other way to put it is representing facts in the way that is beneficial to your case. I mean, if they flat out lied about the facts, the other party could, in theory, object. If they chose not to, then they chose not to. So that's what's going on there. I don't know what else to tell you. Okay, let me do. Let's get this. Oh gosh, I got to get this live stream pulled up over here, because we got to get this started. I think Nelson went about 3 hours, so we're gonna be tight on time today. I also heard the judge interrupted Nelson. Now, I haven't watched this, just so you know. I'm going into this blind with you. We're doing this together. We're doing it live. We're doing it live. Let me I do need to go. I need to grab a non-alcoholic beverage to keep my voice hydrated. I'll be right back. Right back. All right. Sorry about that. I had a beverage down here and I forgot that I must have finished it. So that's that problem, I guess. I also did briefly before we get started again. I did do 3 videos today. If you missed any of them, make sure you go check them out. We had Supreme Court just deciding to not hear a Second Amendment case again. We've got Project Veritas as well, and then some of my thoughts on the Chauvin trial. So make sure you check those. And if you're so inclined. If not, don't. I like it when you do, though. Appreciate it. Helps me out. And the final bit of drama today was Emmett Plant, I guess, is really mad that I called him a fatso. And he had a bunch of excuses as for why he's a fatso. No excuse as to why he uses like a 40-year-old profile picture and tries to pretend like he's not a big hefty boy or whatever, tries to pretend that he has hair, tries to pretend that he's not an ugly cancer AIDS riddled pile of garbage. I don't know, but it's right in character for him to completely lie about who he is, what he is, and for no discernible reason. But that's who he is. He's really mad about it, which is funny because you shouldn't tell me what makes you mad. I'll just do it more. And the tells on this guy are great. He's obsessed. He's obsessed with popularity. He's obsessed with income, and he's obsessed with not looking exactly how he looks. And I don't know why. Like, I have no idea why it bothers him so much. Those three things. He projects them onto other people. Like, oh, you're just jealous you're not as popular as me. It's like, who's trying to be popular? What are you talking about? So anyway, the guy's a weirdo. I've been making fun of him on Twitter all day. And the beatings will continue until morale improves. We'll put it that way. Oh, and finally, if you didn't know, Susan Wojcicki from YouTube got the YouTube Free Expression Award. Was the Free Expression Award for the CEO of YouTube. Thank God. Thank God. Nowhere is as free to express as YouTube. So glad they gave it to the right person. Let's get a move on here. Oh, come on. I got it on the wrong output. For me. Not for you, but for me. Okay, here we go. Here's Eric Nelson.
Counsel, Mr. Chauvin, members of the jury. I want to take this opportunity first to thank each and every one of you for your service, your diligence, and your attention to this matter. We all recognize the disruption that jury service places on your personal and professional lives, especially in a case of this magnitude and duration. And
oh my God, can you be louder? Hold on. I've got to boost. Are we serious? This is max volume? Hold on.
So on behalf of Mr. Chauvin, I want to thank each and every one of you for your attention and service to this jury. I'm going to apologize if I get a little long-winded, because I get one bite at the apple here. The state has an opportunity to rebut my statement after this. There's so very much we need to cover. There's so very much we need to talk about, and it is all important. Before I begin my review of the evidence in this case, I would like to address two very crucial points of law, and they were touched on by the state.
Ooh.
The presumption of innocence and what proof beyond a reasonable doubt means. The presumption of innocence, the defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges, and this presumption remains with him throughout the course of the trial, the presentation of the evidence, throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence. We talked about this in jury selection. We talked about the starting point. The defendant doesn't have to try to catch up. He starts at the presumption of innocence. proof beyond a reasonable doubt. Here's the definition that the judge just read.
Okay, I'm going to try not to pause too much, but that's again, that's a critically important factor in all of this, is that he has a presumption of innocence. It's real easy to look past the presumption of innocence in all of these cases, and in any case. Hell, I mean, just think about how some people look. They come into court in handcuffs. Now, Chauvin's got a suit because he has funding and he's got a legal team who know he needs to be in a suit or whatever. But a lot of defendants come into a courtroom from a jail. They come in some sort of jail getup. They're handcuffed. Sometimes they're handcuffed to the table. Sometimes their feet are cuffed. And it's hard to maintain this idea that they're presumed innocent when none of that appears to be the case by looking at them. But they are. And with Chauvin, he's supposed to be presumed innocent from the start, but it's hard for a lot of people to look at him as innocent, including me, by the way. Including me, it's hard for me to just look at him and say, well, he's innocent, because I have my own set of biases about the situation, about police force and all of that stuff. And none of that actually matters for this case. None of that matters for this case. And so what I have to do as me is try and work around those issues. It's not always that easy. It's not always that easy. And I'm conscious of it. I'm cognizant of that fact. And even for me, it's a little bit challenging to do that. So it's good that he's opening up with this presumption of innocence. And we're going to try and bear in mind throughout all of this, the way he's choosing to do stuff. But it's important to remember that he is, he is doing this, I guess, how do I word this? He's delivering a 3-hour thing, but he's got some intentionality to the timing of each of these subjects. Now, the middle is going to be probably fact heavy and a little bit boring, but his opening and his closing are going to be big hitter pieces for him. So we're going to take a look at those things and focusing on the fact that he's innocent and the burden that the state has to make is that's clearly the strategy they're going for. We'll have to judge on how well they do it. Just laugh and honk your nose says, my prediction is he's found guilty on manslaughter. Media then buries the lead and reports he's acquitted of murder charges, and we get a sequel to The Summer of Love. They will stoop to any low to sell the narrative. Very possible. I have been saying for a little while now that my gut feeling, and this isn't based on law or logic or reason, my gut feeling is that they acquit him on the murder charges and they do convict him on the manslaughter 2 charge. I just think that is, and not that this is proper, okay? This is not a proper necessarily distribution of the verdict. I just think that's a way for the jury to punish him while still mitigating away some of their reservations about prosecuting a cop. I think that is a reality that we need to face in this, and that is my personal opinion. Whenever people have been asking me over the past couple weeks, that's where I go to. I think, and I'll be candid about this in the same way I was candid in my video earlier today, I think the prosecution has made their case. I think the prosecution has made their case for either manslaughter or murder. Now, I think the defense has made at least enough of a case to beat the murder charge. I'm not 100% sure on the manslaughter charge because I haven't watched everything. So who knows if they have, but I think the defense has done a good enough job for the jury to, to go either way on this one. So I do think it's up to the jury on how they'll decide this. It's not clear cut, and we'll probably see some long deliberations, but we'll see. We'll see.
Read you. Proof beyond a reasonable doubt is such proof as ordinary prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt that is based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The law recognizes 3 standards of proof. The preponderance of the evidence is the first and lowest standard. Clear and convincing evidence is the next standard. And the third standard is proof beyond a reasonable doubt. And the way we lawyers sometimes illustrate what these three standards mean is through the scales of justice, right? The scales of justice equally balanced. When you apply the standard of the preponderance of the evidence, it's also called the scintilla of the evidence. A single grain of sand tips the scales in the favor of one party or the other. And this burden of proof is used in many civil cases. If the state wants to take away your driver's license, for an example, that is the burden of proof that the state has in that type of a case. They have to just ever so slightly convince the finder of fact that their evidence supports their action.
It never actually works out like this in any of the standards of proof, so that's fun.
And convincing evidence. I mean, that's pretty self-explanatory, right? It is clear evidence, and it convinces you, the finder of fact, that the action is correct. This is the standard of proof that is used if the state wants to take away your children. Clear and convincing evidence. It tips the scales more in the favor of one party over the other. The highest standard in this country is proof beyond a reasonable doubt. Proof beyond a reasonable doubt. Essentially, what the state has to convince you is that the evidence in this case completely eliminates any reasonable doubt, or in other words, leaving only unreasonable doubt. Capricious, fanciful. Capricious doubt, capricious means unpredictable. Fanciful, space aliens flew in, inhabited the body of Derek Chauvin, and caused this death.
I mean,
that's fancy.
Carbon monoxide from a car exhaust might also be capricious.
The reasonable doubt.
I'm just saying that was a bad argument in my opinion.
Doesn't mean beyond all possibility of doubt, because I suppose space aliens may have been inhabiting his body, but that's obviously fanciful and capricious. So these two standards, the presumption of innocence and proof beyond a reasonable doubt, work in concert with each other. You start with the proposition that Mr. Chauvin is innocent of these charges. The state has to advance substantial evidence to convince you that the only doubts that are remaining are unreasonable doubts.
Tina says, Nick, did you see that the FedEx shooter was a brony and he hoped he would be with Applejack when he died? What a weirdo. Me, I want to be with Rainbow Dash when I die. Stop it. Stop it. No guns for bronies. We can get behind that.
As you analyze the evidence in this case, you would simply have to find that any defense that has been advanced.
Okay, yes, I see. Oh, yes, the prosecution announced that his oxygen level was 98%. Listen, you guys have got to stop looking at this trial as from the internet's perspective. You have to, or you're going to be really frustrated with the results. That's all I'm going to say about it. The jury didn't see that as a gotcha. I don't know that. I'm strongly suggesting and betting that the jury does not see that as the gotcha argument that the internet does. That's my humble opinion. You're free to disagree, of course.
Is unreasonable. That's what this standard is all about. I want to take this opportunity also to talk to you about the importance of reading the entire instruction. Because I've seen and lawyers, and I'm going to do it too, right? We pick and choose those things that help us make our case and help us argue our case. That's our job as lawyers.
Yes.
Is to point out words and phrases within the instructions that make the difference in the case.
I have a minor disagreement here. I'll talk about it in a second.
And present it to you in such a way that it supports our proposition. That's what we do. That's why you are instructed that if your memories of the evidence is different, that if the judge's law is what applies. But take the time to carefully read the entire instructions.
Okay, I think my minor disagreement there is I don't think he should suggest that he has the same job as a prosecution in picking out evidence. What I think he might want to say is, we're both going to pick out evidence that favors our side. It's my job as a defense attorney to pick out the places where doubt is reasonable and show you those. Whereas the prosecution isn't allowed to pick and choose. They have to make a full case. They have to show you everything. If they're picking and choosing, then what aren't they telling you? Whereas for me, I'm picking and choosing because I'm only going to focus on the places where there's doubt. That's my stylistic disagreement with Eric Nelson here. I don't think he should equate himself with the prosecution. I think he has a different job, and personally, I'd be a little more open about it. He's also doing the trial, so I'm not criticizing, just putting out a minor difference of opinion.
Throughout the course of this trial, you've seen us do
backseat lawyering. Yes,
Little
yes.
snippets.
Do better, Nelson.
A second here, a second there, a screenshot here, a screenshot there. You need to review the entirety of the evidence in this case during the course of your deliberations as well. And I can tell you that some of the videos that we've seen, they're much longer than what was presented in court. There's additional information, and you're going to see some of that as we go through this case today. So take the time and conduct an honest assessment of the facts of this case, compare it to the law as the judge instructs you, and the entirety of the law. That's why the instructions tell you, consider the instructions as a whole. I've told you that lawyers like to present evidence that favors them, right? But we have to be intellectually honest about the evidence. We have to present it in an honest and intellectually cohesive and coherent manner.
Okay.
And I have to address something that I think is important. And I think it is a prime example of what I am asking you and what is your obligation to do to look at the evidence in light of all of the other pieces of evidence, right? So you heard during the testimony of Dr. Fowler that one of the things that he considered is the possibility that carbon monoxide was present and could have contributed to an environment that created an oxygen deprivation. You heard that testimony. In rebuttal to that testimony, the state brought Dr. Tobin back in, and he told you, we can completely disregard that. We know as a fact, we know conclusively that Mr. Floyd did not have carbon monoxide because his oxygen was saturated to 98%. And you just heard the state say, just like I am right here, right? So it stands to reason. I could get up in front of you and I could argue to you, we know this wasn't asphyxiation because George Floyd had a 98% oxygen level. How could he have been asphyxiated at the hospital with a 98% oxygen level?
Now, see, he's bringing it home to them here. Now, again, mind you, I haven't watched this, but we'll see. We'll see how he does with this point. This will be interesting.
but that's not intellectually honest. It doesn't stack up against the rest of the evidence because of what we know, right? We heard the testimony of Seth Bravender and Derek Smith, the paramedics. We heard the testimony of Dr. Langenfeld. They came in and they said they began resuscitative efforts. They introduced oxygen, an oxygen supply. They're manually breathing for him. They're reoxygenating his blood. So when you look at that piece of evidence, when you look at a piece of evidence like that, you have to compare it against all of the other evidence.
Okay, so this is a weird sort of tack, right? So he's going he's taken the 98% oxygen argument, and then he's also destroying the 98% oxygen argument at the same time, which is, I guess, in the quest for honesty, he's doing that. So he's saying, here's that 98% oxygen, so we know he couldn't have asphyxiated. But wait, we know he could have asphyxiated because that oxygen level wasn't actually as high. They just introduced more oxygen in there. So that's an interesting approach to this one for me. Because now you're back to asphyxiating. Yeah, I know 98% means he did not suffocate, but he said that they know that the 98% is from the resuscitative efforts where they're breathing for him. They're introducing blood or oxygen back into the bloodstream. So he's getting rid of that 98% number right now in his argument.
Because you can't come in and say, George Floyd, on one hand, George Floyd died of asphyxiation, but he has a 98% oxygen level, right? His blood is oxygenated. Then it stands to reason the opposite is true as well. You can't come in and say, I can conclusively prove that Mr. Floyd didn't have carbon monoxide in his blood because he had this high oxygen saturation. You test one statement against the evidence of other people and you compare it. That is what you as jurors are obligated to do and what I am asking you to do. Compare the evidence against itself. Test it. Challenge it. Compare it to the law. Read the instructions in their entirety. Start from the point of the presumption of innocence and see how far the state can get. I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt. Mr. Chauvin has been charged, as the state indicated, with these 3 charges, and the judge has instructed you. Count 1 is second-degree murder while committing a felony. It's also called the felony murder rule in Minnesota. Kind of the textbook example is I run into a liquor store, I pull a gun, I'm intending to rob the liquor store. My gun goes off, I shoot and kill the teller. I didn't intend to go in and murder that person, but the death of that teller occurred while I was committing a felony. That's the felony murder rule. He's been charged with murder in the 3rd degree for performing an intentional act that is eminently dangerous. Right? You've seen the instructions, you've heard them. And manslaughter in the 2nd degree. Again, the law has all of the words, it defines the words you need, and the instructions should be considered in their entirety. Whenever I meet with a client, I try to explain what the elements are, and this is the analogy that I use. Okay. I say that
let's hear it.
a criminal case is kind of like baking chocolate chip cookies,
Oh,
You have to have the necessary ingredients. You've got to have flour and sugar and butter and chocolate chips and whatever else goes into those chocolate chip cookies. If you have all of the ingredients, you can make chocolate
stop pretending you don't know what goes in a chocolate chip cookie, Nelson. Stop it.
chip cookies. But if you're missing any one single ingredient, you can't make chocolate chip cookies. It's a simple kind of analogy. But the criminal law works the same way. We say we call the ingredients the elements. The state has the burden of proving each and every element beyond a reasonable doubt. Not just some global proposition that they've proved their case beyond a reasonable doubt. They have to prove each of these elements beyond a reasonable doubt. And if you determine that they have done so, you convict. But if they are missing any one single element, it is a not guilty verdict. And you saw the spreadsheet that the state put up, right? The elements are a little different in each of these cases. And some of these elements will take less of your consideration. You will have to look at the evidence, and you will have to, for example, determine is Cup Foods in the city of Minneapolis, is Minneapolis in the county of Hennepin, is Hennepin County in the state of Minnesota?
No.
Did this happen on May 25th,
None of it's true.
2020? Right? It's going to take
a different
less
day,
of the consideration,
pre-tape
but
by the
nevertheless,
FBI.
You have to do that if you go through that process. Two of the elements that I want to focus on during the course of my discussion here today, two of these elements are common throughout, or two of these issues are common and apply to all three counts. And so I want to focus my remarks today on those two issues. The first, were Mr. Chauvin's actions an authorized use of force by a peace officer, right? Because in the instructions, it specifically tells you no crime is committed if it was an authorized use of force. Period. End of discussion. The second is an element that is and does appear in all three counts. That is the cause of death. What caused Mr. Floyd's death? And we're going to talk about that second. So, let's start with the concept of reasonable force. As the instructions read in their entirety, no crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation.
Chauvin's over here playing Candy Crush on his phone. What's he doing? What's he doing there? No, this is the trick here. Nelson's going to take a stab at the elements and go for a couple things. Was the force that he used reasonable? And I think there's a really good argument to suggest that Chauvin's use of force, especially at the beginning and through a good chunk of the encounter, was absolutely reasonable under the circumstances. And I know he's going to bring up some stuff later about how he had other tools at his disposal, because I saw very small snippets of this, but that's the question. Is it reasonable? And this is why I never really liked the murder to charge. I think there's too much reasonable doubt in the actual charging of a police officer who's effecting an arrest of someone and not using any sort of techniques or moves or activity that looks overtly horrifying to people. I mean, it's horrifying to watch someone die, but you got to understand, or I keep saying you got to understand, and you got to understand that it's just an affectation that I use. I don't mean you've got to understand. I know most of you guys actually do understand this. But the point of this is the idea that an unreasonable amount of force is being used is actually dampened by the length of time of the assault, right? So if the force is unreasonable, you would expect it to be like unreasonable force to most people is jarring, shocking, offensive, that sort of thing. The idea of like an officer punching someone in the back of the head and smashing their face down into the concrete or something, or breaking fingers or an arm, or pulling up so hard that it dislocates their shoulders. Some sort of visceral, nasty movement that is painful and jarring to watch. That's how we picture internally and inherently how we picture unreasonable force when we hear it. We don't think about doing something mundane like applying pressure to the back or neck of a suspect, but doing it for a really long period of time. So I think they have problems with the underlying assault charge just from an internal sort of logical assessment. That's not the proper legal analysis. But to me, when I hear unreasonable use of force, I'm thinking a gun, a stick, a knife, a taser, some sort of thing is being used to apply this amount of force, a broken limb, cuts, abrasions, severe bruising. We know from the medical reports there's no bruising even on George Floyd. And that's part of the place where I would focus this. It's like, how do you have unreasonable force and no even superficial wounds to show for it? And that's where I think the manslaughter 2 charge becomes the better charge in this case, is that I think at some point there's a transition from the assault into a duty of care that's assumed by the officers when they put him into handcuffs. And that especially once they find out that he doesn't have a pulse and that he stopped responding, that they should have maybe administered some care at that point. Now, I'm not saying that that's definitely what did or should have happened or anything like that, but that's where my brain goes on these sort of questions. And that's where I see a bigger amount of fault going to Chauvin. Should he have done something different than he did? And that's where I think the stronger case is. So I'm not sure if the defense is going to tackle that or not.
Would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer and without regard to the officer's own subjective state of mind, intention, or motivations.
And see, again, that's what I think that feeds into a good defense on the second-degree murder, for sure. The idea that he's applying this force, he comes up to the situation, the guy's resisting getting in the car, he kicks himself out the other side of the car, the crowd is there, they have to secure the area, and I think they did a good job of laying that out. So
the defendant is not guilty of a crime if he used force as authorized by law, and to prove guilt, the state must further prove beyond a reasonable doubt that the defendant's use of force was not authorized by law. So, if you remember from my opening statements and how I talked about reason and common sense, right? The reasonable police officer standard. I want to just briefly add one thing here, is the standard is not what should the officer have done in these circumstances. It's not what could the officer have done differently in these circumstances. The standard is what were the facts that were known to this officer at the precise moment he used force, and considering all of the totality of circumstances and facts known to the officer, what would a reasonable police officer have done? You have heard from numerous experts, police use of force experts, the training department from the Minneapolis Police Department. You've heard from police officers, street police officers, Sergeant Edwards, Sergeant Pluger, right? So you've heard from these people, and they have given you their opinions at various stages as to the reasonableness of the use of force.
Gerard Garvin says the OJ trial was a 10 out of 10. It had great characters, twists and turns, etc. This trial has judges in masks, lawyers behind sneeze guards, and it's just overall sad. 2 out of 10.
But one of the things that one of the things that all of these police officers effectively agreed to is that when you look at the question of what would a reasonable police officer do, knowing the facts of the case, there are things that a police officer is entitled to take into consideration above and beyond the facts, right? Their training, the training that they receive, their experience as a police officer, the department's policies on the use of force. And all of these things kind of lead into the question of, most critically, what are the facts that were known to the police officer, the reasonable police officer, at the precise moment the force was used? So you can start at a very high level, right? What were the reasonable police officer's knowledge of the area be? Is this a high crime location? Is it a low crime area? Those are facts that a police officer would know. What are the specifics of the location of arrest, right? Am I going into a densely populated urban environment, or am I in a kind of a secluded backyard, right? Officer is calculating these pieces of information and assessing the risk, assessing the threats.
Viden, the cold one, said, "Hey, Nick, I'm exhausted, but I moved into my new apartment. I have to use my mobile data for now. Internet should." I agree, the internet should.
Officers are entitled to kind of take into consideration things that you and I don't think about. Their tactical advantages, their tactical disadvantages. They can take into consideration the scene security, keeping the scene secure, and security of the scene, right? Those are two different concepts. So kind of, again, focusing back into what facts were known at the precise moment force is used, you can then take into consideration kind of this mid-range level of information. A reasonable officer wants to keep his fellow officers safe. A reasonable police officer takes into consideration the safety of civilians. The reasonable police officer takes into account the safety of the person that they are arresting. They take into account, what resources do I have based upon? How close am I to a hospital? What's the expected time if I call EMS? Because a reasonable police officer at times, they got to put the person in their squad car sometimes and take them because they're farther away. Calling for help, bringing help in would take longer than it would simply to take the person directly. And then you look at the direct knowledge that a reasonable police officer would have at the precise moment force was used. That includes information that they gather from dispatch, their direct observations of the scene, the subjects, and the current surroundings. They have to take into consideration whether the suspect was under the influence of a controlled substance. They can take into consideration, because again, this is a dynamic and ever-changing, just like life. Things change. It's a dynamic situation. It's fluid. They take into account their experience with the subject at the beginning, the middle, the end. A reasonable police officer tries to predict or is at least cognizant and concerned about future behavior based upon past behavior. But the unpredictability of humans factors into the reasonable police officer's analysis too. Because sometimes reasonable police officers take someone into custody with no problem, and suddenly they become a problem. It can change in an instant.
Okay.
A reasonable police officer will take into consideration his immediate surroundings. Are there bystanders?
I don't know if I agree with this tactic. He's doing a lot about the reasonable police officer, and he's spending a lot of time on it. Now, he has a ton of time, but to me, I think that you've got the jury's already thinking these things, in my opinion, and maybe I'm wrong. And again, I'm not trying to backseat lawyer this thing. It's just my personal opinion. I don't like things going this long, because they start to get very, very repetitive, monotonous, and boring. And I'm going to criticize Nelson a little bit right now. I'm bored listening to him, and I think the jury may be bored too. And so I don't know that he has to spend this much time droning through reasonable police actions. I think people know a little bit about that, and I think he can more quickly and effectively get to those points and then move on to more interesting points. That's my opinion.
Are there civilians? A reasonable police officer will take into consideration who he is at the scene with. Are these veteran officers? Are they rookie officers? What do I know about my partners and my partner's abilities? So throughout the course of this trial, the state has focused your attention on 9 minutes and 29 seconds. The proper analysis is to take those 9 minutes and 29 seconds and put it into the context of the totality of the circumstances that a reasonable police officer would know. And the proper analysis starts with, what did the officers, or what would a reasonable officer know at the time of dispatch? Well, these are records that are kept. They've been introduced. You can look at them. This is Exhibit 151. This is the computer-aided dispatch report. You heard the testimony of Jenna Scurry, the 911 dispatcher. This is information that they are passing out to the officers. You will see that the initial information that a police officer has in his squad car, looking at his computer or hearing over the radio, was that on May 25th, 2020, at 20:02:13, so that's 8:02:13, a business, Cup Foods, who police officers have the obligation to respond to these calls, whether it be from a person or a business.
They do not have an obligation to respond to the calls.
But a citizen of the state of Minnesota, Minneapolis, runs a business, and they called for assistance. And they told the officers.
They should, but they
The
don't.
reporting party, there is a male who provided a counterfeit bill to the business. He's 6 feet tall or higher. He's sitting on top of a blue Mercedes ML320 SUV. The license plates also appears this subject is under the influence. So the analysis of what a reasonable police officer would know in this circumstance is that a business is requesting its help. The suspect is still there. He's large, and he's possibly under the influence of alcohol or something else. So the analysis begins at 8:02 and 13 seconds. You may recall the testimony of Jenna Scurry as well, and it's not reflected in this exhibit pretty well, but in the evidence, exhibit number 10, you can hear the audio recording of the dispatch, Jenna Scurry to the officers. Jenna Scurry informed you that initially Officer Chauvin was assigned to this call on a Code 3 Priority 1 basis. It's Code 3, get their lights and sirens, get there fast, right? It's Priority 1 because the suspect is still on scene. So per the Minneapolis Police Department policy, get there fast, the person is on scene, right? That's what she testified. And then very quickly after that, that occurred at 8:04 and 28 seconds. Then what you see is what she told you was that the sector car 320, that's the car that patrols this part of the city, said, hey, we can take this call, and Officer Chauvin and Officer Tao were canceled from the call, right? So they were canceled from the call. And sector car 320, Officers King and Lane took it, and that occurred at 8:05 and 11 seconds. When Officer King and Lane took it over, you can hear, again, you can go back and you can listen to that audio of that dispatch, and you can hear them talking to each other. Officers King and Lane arrive at the Cup Foods at 8:08 and 20 seconds.
King? Okay. Ooh, feet doxed. Watch out.
So now we see police officers are responding. They're on scene at 8:08. Both Jenna Scurry and Peter Chang described that during the course of the interaction between the initial interaction between Officers King and Lane and Mr. Floyd, through dispatch they heard what sounded like the sounds of a struggle. Jenna Scurry described she's trained to listen. She heard these sounds of a struggle, and she aired out on her own, other officers need to respond, Code 3, to assist Officers King and Lane, right? So a reasonable police officer, he's going emergent to a scene, he gets canceled from the scene, he's now being told that other officers need assistance, and step it up, get there fast. So you can see again, based on the records, that at 8:10:08, 20:10:08, backed up 320 with 330, right? So now 330 is Officer Chauvin and Tao. They're backing up Officer King and Lane. And you can see Peter Chang respond at 8:10 and 21 seconds. You hear 320 taking one out. So that means they're removing someone from the vehicle at 8:11:02. The scene is ultimately C4, Code 4, all clear at 20:12:21. So literally this demonstrates to you a couple of things. How quickly a situation can change from second to second, minute to minute. They went from get there fast, back off. Get there faster because someone needs help. It's clear. The situation is dynamic and it's fluid. They're provided with information that an officer needs assistance. They testified about the sound of a struggle, right? And if you recall, Sergeant Steiger specifically said all of this information would be known to a reasonable police officer. And it goes into and factors into the reasonableness of the use of force. Ultimately, Officer Chauvin and Officer Tao arrive at Cup Foods. Just pause this for 1 second here. Sorry. When we look at Officer, I just have to give you a little piece of information. When we look at Officer Chang's video, Officer Chang arrives first. You see the time is 1:16:33 Z Zulu. That's Greenwich Mean Time. Subtract 5 from 1 a.m. get you back to 8.
I'm not going to speed up the video because I want the effect of the argument, not the effect of the chipmunk version of the argument.
Officer Chauvin and Officer Lane pull up. 8:16. Go over there.
Okay, just stay put, all right? I don't want anybody near his car.
Information gathering in terms of this assessment and reassessment of, again, the decision-making process of a police officer, right? Don't come over here where I am, Officer Chang says. Go over there. They need your help. Because what at that point, at that precise moment, they don't know what's happening over at the squad car. They don't know that Officers King and Lane struggled with Mr. Floyd, getting him out of the car, that they sat him down, that they stood him up, that they walked over. They haven't seen any of this information, and there's no evidence to suggest that they had. So that doesn't factor into the information. It's, again, a reasonable police officer. What do they know? And they don't know that. But they're starting to get some indication, hey, go over there, right? Go over there. You can see right at about 8:17, and I apologize for the quality of the picture.
Yeah,
Officer
it's your
Chauvin
fault, you
is
jerk.
arriving and walking up to the squad car. So what would a reasonable police officer see in this instance? What a reasonable police officer would see could be defined, because again, a reasonable police officer has to be aware of his department policies. Active aggression or active resistance. Let's call it active resistance. A response to police efforts to bring a person into custody or control for detainment or arrest. A subject engages in active resistance when engaging in physical actions or verbal behavior reflecting an intention to make it more difficult for officers to achieve actual physical control. So as Derek Chauvin walks up to this scene, he has all of the information from dispatch. He has all of the information from Officer Chang sending him over. He knows his department policy on the difference between active aggression, active resistance, passive resistance, based on policy, training, etc. This is an officer's consideration of, again, the use of force. All of these things factor into it. So what does he see? He sees Officers King and Officers Lane struggling with
Chauvin has the hardest job
Mr.
during all of
Floyd,
this.
attempting to put
Don't
him
draw any
into the
attention to
car.
yourself. Stay
He
stone-faced.
hears the words that Mr. Floyd is saying at that point. I'm claustrophobic. I'm a good guy. I'm a good man. I'm claustrophobic. I just had COVID, right? He's hearing this information. He's observing with his eyes. A reasonable police officer is observing this with his eyes and his ears and assessing what he sees pursuant to policy. And what he sees, at a minimum, is active resistance. Mr. Floyd's not just simply getting in the back seat of the car. So let's watch. What does Officer Chauvin see when he walks up? This is from his body camera from 8:17 and 21 seconds to 8:18 and 15 seconds. Just shy of a minute.
Oh, God.
You can't win.
I'm not trying to win.
Go get in the car.
I get on the ground, anything.
Go get in the car.
He know it.
Ain't no way to Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please?
Hey, so you get in this car, we can talk.
I am claustrophobic.
I'm hearing you, you're not working with me.
God, I'm claustrophobic right there, man.
Get in the car.
Get in the front. Please.
No, you're not getting in the car.
I'm claustrophobic,
Get in the car.
Okay? I'm not a bad guy, man.
Get in the car.
I'm not a bad guy. You ain't gonna win. Oh, man. Oh, please, officer. Please. Please, man. Please.
Hold on, man. No. Take the seat.
At this point, they really should have just closed the doors, in my opinion.
My wrist, man. Please. I can't take that, man.
By 8:18 and 15 seconds, Officer Chauvin has not laid a finger on Mr. Floyd, but he's observing. And a reasonable police officer is doing this. He walks onto a scene. He sees active resistance occurring, potentially.
That doesn't change the analysis of the case in any way, by the way. It's just my personal opinion.
Officers. He has not intervened. But again, based on the policies and the training that you have seen, what were his options available to him at that time? If a person is actively resisting in the center, distraction techniques, controlled takedowns, conscious neck restraints. Can you clear that in? Right. These are options available.
I accidentally
to Mr.
doodled
Chauvin
over
at
conscious.
this point. He has, per his training, these techniques at his disposal. A reasonable police officer would be making these observations. He would observe the white foam around Mr. Floyd's mouth. He would consider the possibility that this person was under the influence of something. Basically, using the information from dispatch, making these observations, how is he analyzing this? How would a reasonable officer analyze this, and what would be known to a reasonable officer? A reasonable officer would look at the size of the person.
Tasman 3002 says, how likely do you think it is that the jury votes guilty out of fear of reprisal? And is there historical precedent for this or recourse for the defendant? I mean, yeah, they could. We'll never know whether or not they did. Juries, of course, have done this in the past, finding people guilty for any number of improper reasons or not guilty. Well, there really isn't an improper not guilty verdict. If your jury of your peers does not find you guilty, then you're not guilty, and that's fine. But there's been plenty of improper guilty verdicts throughout the years. The immediate challenge would be to say that the fear of reprisal, the pressure on the jurors, is what caused their guilty verdict. That's up to Chauvin's defense attorney, Eric Nelson, to make a motion for a mistrial, to appeal that motion, to carry that to the appeals court and argue it there. It's a long shot, though, without more evidence. So we'll see how that goes.
And assess that person's size in relation to his own size. Because it's a part of the risk-threat analysis, right, that we've heard about so much. A reasonable officer would know that these are two rookies putting this man in the car. In fact, as the evidence established, Mr. Chauvin trained one of the officers.
Oh, good job, Derek.
So a reasonable officer may step back at this point to see if these two guys can get this under control. A reasonable officer will hear the words that the suspect is saying. I'm a good guy, I'm a good guy, I'm a good guy, I'm claustrophobic. And he's going to compare those words to the actions of the individual, right? Because this is part of the analysis. Because I can say, I'm going to cooperate with you, I'm going to do whatever I want. But if my behavior is inconsistent with what I am saying, a reasonable officer takes that into consideration. In fact, a reasonable officer who's aware of his department policies knows the de-escalation policy that is in place. And part of what a reasonable officer has to do is to consider whether a subject's lack of compliance is a deliberate
I think he's trying to focus
attempt
on
to
the
resist
massive amount of
or
information
an inability
that
to comply
is in a
based
cop's
on
head
these
as they're making
factors.
decisions, even though it's not
Medical
really like
conditions,
that.
mental impairment, developmental disability, physical language, language barrier, influence of drugs or alcohol, or behavioral crisis. So an officer, a reasonable officer, has to take the information and assess, is this suspect purposefully or intentionally, deliberately trying to thwart our efforts to take him into custody, or are they experiencing one of these other types of factors? But such consideration, when time and circumstances reasonably permit, shall then be balanced against the
Soli Dea Gloria says, have you been a cop? No, I haven't been a cop. But you don't have to be a cop to know that it's ridiculous to think that an officer is running through a giant checklist of things like he's presenting here in trial in his head. Think of literally anything you do. Anything you do has a huge checklist of things, but our brains don't work that way. Our brains internalize large amounts of information and eliminate irrelevant and frivolous sort of decision-making automatically and point us towards pulling up the most important elements of it. So I think he's trying to appeal to the idea that cops have to make a lot of considerations. But you have to make a lot of considerations when you go to the grocery store too. But really what you do is you go buy bananas, milk, cereal, and bread. You don't go, well, there's 4,000 different cleaners and let me go through the checklist of each one I don't want to buy. It doesn't work that way. But if you wrote comprehensive instructions on how to go grocery shopping, it would look pretty much the same. So he's doing it. I don't know that it's that effective. I know it's really boring and it takes a lot of time. And again, I think the jurors probably know this, and I think they could be brought to this point faster. That's just my criticism of this. And again, it's not like he's doing a bad job. It's just a disagreement in style.
The incident facts when deciding which tactical options are the most appropriate to resolve the situation safely. So again, reasonable officer, based on the totality of these circumstances, is going to take all of this information in, all of these policies, all of these training ins, and a reasonable officer at that point would conclude that the amount of force that was being used by officers King and Lane was insufficient, was not enough use of force to overpower Mr. Floyd's resistance to getting into the car. He's seen it, he's heard it, he's familiar with the policies, and so at precise.
Oh my God, no, the stress of a life and death situation surrounded by a possible mob of people is not the same as grocery shopping. I fucking get it, okay? It's not why is this so goddamn hard? Look, the point, he's not even at that situation yet. The crowd hasn't shown up in his argument. He's still literally at the point of putting the guy in the car. And we're nowhere close to it at this point. I'm using an analogy to point out that literally anything can be given a giant list of instructions that your brain sorts through without you thinking about it. I don't think this is effective. The jury knows this. These jurors probably know cops. They've dealt with cops. They've watched cop shows. They go through this all the fucking time. Everybody does. No one's out there going, you know what? Cops just show up and try to decide whether they want to shoot black people or not. I don't think the jurors are doing that here. I don't think that's a thing. I'm going to disagree with this strategy over and over and over because I think this is way too wordy. If you don't like that, leave. But that's fine. But just go, because I'm gonna talk about it. If you can't deal with an analogy, fucking leave again. It's so ridiculous to sit here and be like, well, life or death. He's not even at the life or death situation. He's not anywhere. And I don't actually think that Chauvin thought he was in a life or death situation either, because I don't think he's a bad cop necessarily. I think he might have made some mistakes during this day, but I don't think he looked around and goes, oh my God, these people are going to murder me, because he's been in situations like this most likely in his career and wasn't murdered or even close to it. So let's stop with that. Let's stop with the whole, oh, this comparison doesn't work because it's not the same. Okay, here. Now, you're going grocery shopping and you've got a gun to your head. Okay, it's the same fucking list that your brain goes through. There's just a gun to your head. That he's not arguing about the life or death situation here. He's arguing about what a reasonable cop does in this situation when he hasn't even touched the person yet.
Precisely 8:18 and 15 seconds, Officer Chauvin goes hands-on. Officer King, Officer Lane, and Officer Chauvin.
They literally were at the grocery store.
However, whatever adjective you want to use. They struggled with Mr. Floyd from 8:18 till 8:19 and 12 seconds. About a minute, a little over a minute. It doesn't really seem that it's that long of a time, but again, the amount of physical exertion. Remember how Sergeant Jody Steiger described this. When the apparent attempts to get him into custody were futile. I wrote his quote down.
I'm switching to gin because of you.
The futility of their efforts became apparent. They weren't able to get him into the car. 3 Minneapolis police officers were not able to get Mr. Floyd into the car. They themselves are experiencing that surge of adrenaline. A reasonable police officer will be experiencing that surge of adrenaline. And again, balancing all of the evidence against each other, right? Let's look at 3 different angles of this struggle. This is Officer King's body camera.
I'm going down. I'm going down. I'm going down.
Get in the squad.
I'm going down. I'm going down. I'm not going to leave you. Bro, you walked down a heart attack, man.
As Chris Brown walks up and is like, tell me, are you down, 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 down? Paul Durfee says, hey, Nick, just got done watching your video on employers forcing employees to get vaccinated, and I was wondering if those same rules apply to public employers like the court system or Office of the Public Defender. Thoughts? That's a different question, and I'd really have to think about it. I don't know the answer to that. Most likely, yes. I think on that, because I don't think a vaccination is... I mean, you'd have to make the argument that it's political speech. It'd be a tough one. I think he'd still be fired. So there you go. There you go.
I know what they bring. Get in the car. I can't go, man. I can't breathe.
Take a seat.
Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Can we figure out what's going on?
Forgery for what? Take him out. For what? Please, man. I can't fucking breathe.
Hey, come on out.
Look at you. Thank you. Thank you.
Get him down the ground. Yeah, on the ground. On the ground.
My visa.
He's under arrest for forgery. Forgery for what?
By the way, that was a good a criticism that I had that of the initial officers. They never told him what he was being arrested for. That was my opinion, a problem from the original officers. Not like a critical error, not like, oh, well, everything's justified or anything like that by Floyd. I'm just saying that's something they should have covered when they arrested him. That being said,
this is the video of the same time period from Officer Lane.
I'm on the ground. I'm on the ground. I'm on the ground. Get in the squad. I'm on the ground. I'm on the ground. I'm going down. I'm going down. I'm going down.
Get in the squad.
I'm going down. I'm going down. I'm not going to breathe.
Bro, you look down a heart attack shit, man. Get in the car.
I know I can't breathe. I can't breathe.
Oxygen, man. Not so heavy.
I can't focus, man. I can't breathe. I can't breathe. Please, man. Please listen to me.
Does he want to jail?
Listen to me.
He's under arrest right now for forgery.
I can't.
Don't you know what's going on?
What?
Just take him out and just
For what?
MRE.
Please, man. I can't fucking breathe.
Here, come on out.
Look at you. Thank you.
Yeah, just when you get up there.
On the ground.
I appreciate that.
Officer Tao.
Man, I'm down the ground. I'm down the ground. I'm down the ground. I'm going down. I'm going down. I'm going down. I'm not going to run, man. Right. I know I can't breathe. I can't breathe.
You're talking and oxygen.
I think showing this video over and over is actually a really good play by Nelson. This is the stuff that I think is a good place to focus on, spend a lot of time, rather than talking so much about reasonable force. Like, just show it.
I can't fucking breathe.
Here, come on out.
Look at you. Thank you.
Yeah, just when you get up
On the ground.
I appreciate that.
A reasonable police officer understands the intensity of the struggle. You can see at points when Mr. Floyd's legs kick back, it actually almost knocks Officer Lane over. Right? It knocks off the body-worn camera and the badge of Officer Chauvin in this struggle. A reasonable police officer
Nothing
would
without that
understand
badge, copper.
this situation. That Mr. Floyd was able to overcome the efforts of 3 police officers while handcuffed with his legs and his body strength. A reasonable police officer standard can be seen in another way, from the milestone camera. And this is what caught the attention of the 911 dispatcher, Jenna Scurry. She said she observed the struggle and the vehicle rocking back and forth, back and forth. Watch the vehicle.
If this police van's a rockin', you know what they say. What do they say? They say you're about to get kneeled on and die. That's what they say. They need Benny Hill music for this with the cops running around to both sides of the car. I just think it'd be funnier. We could really lighten up the death doing it that way too. I like the guy just watching back there, like well back from the car with his hand on his hips. They're doing it wrong. Maladjusted, yeah, they challenged what the onlookers could actually see several times when they were actually on the witness stand.
Reasonable police officers will consider their training, right? And before we talk about the training again, there's something that I think is really important to understand. 2 things actually at this moment. Not a single use of force expert that testified, not a single police officer who testified said that anything up until this point was unlawful or unreasonable. It was reasonable for these officers to put them into Mr. Floyd into the squad car. It was reasonable. The efforts that they took to overcome his resistance were reasonable. Every single expert agrees that to this point, nothing is contrary to policy, training, defensive tactics, crisis intervention, all reasonable. It's at the point that Mr. Floyd is brought to the ground that there becomes dispute about.
Hey, what's up, Good
reasonableness
Logic
of the
and
use
Tug? How you guys doing?
and what a reasonable officer would know. It was Seth Stoughton, the law professor, who said at the point Mr. Floyd came out of the car, putting him on the ground was unreasonable. So, was it reasonable for Officer Chauvin or a reasonable police officer to put Mr. Floyd on the ground in that instant? So a reasonable police officer is going to rely on his training and information, his evidence, what he knows.
Did
all
he
of
say
the
the
information he's built
professor
up to
said it
this
was
point.
reasonable?
You heard
Unreasonable.
Lieutenant Mercil testify about how about 15 years ago the Minneapolis Police Department went to ground defense tactics, getting people on the ground to control them, control the head, control the body, different types of moves that the police use to create and eliminate space. Escape versus control. Those are two different things. These are the tactics that have been employed by the Minneapolis Police Department for 15 years.
I don't want to roll
Why?
it back.
Because it's safer
We'll never
for
get
the
done.
officers and it's safer for the suspects. It keeps people contained, controlled, and confined until they no longer are resisting. A reasonable police officer would also consider his department's policies, including the use of non-deadly force policy. Force that does not have the reasonable likelihood of causing or creating a substantial risk of death or great bodily harm. This includes, but is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. This is the policy, 5-302 of the Minneapolis Police Department, that non-deadly force can be used to physically manage a person.
Yes.
And again, every single person has agreed that the use of force up to this point is reasonable, lawful, and meets the reasonable officer standard. And so we get into the 9 minutes and 29 seconds at this point. And the state has really focused on the 9 minutes and 29 seconds. 9 minutes, 29 seconds. 9 minutes, 29 seconds. It's not the proper analysis because the 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds. It completely disregards it. It says, in that moment, at that point, nothing else that happened before should be taken into consideration by a reasonable police officer.
I mean, kind of though. It's kind of right. It's kind of right, honestly. If his now again, I think there's too much doubt for the second-degree murder charge because of the reasonable use of justifiable force. I think there's too much doubt around that to actually secure the conviction. However, that being said, how he acted and how they all acted and how the prior 16 minutes went isn't that big of a factor in how they're acting now. Because if they were crazy, but they're no longer crazy, then you can't keep applying force. You have to de-escalate. That's in the manual as well. So I don't, well, whatever. This is nitpicky.
It tries to reframe the issue of what a reasonable police officer would do. A reasonable police officer would, in fact, take into consideration the previous 16 minutes and 59 seconds. Their experience with the subject, the struggle that they had, the comparison of the words to actions, it all comes into play. Why? Because human behavior is unpredictable. Human behavior is unpredictable, and nobody knows it better than a police officer.
I mean, someone
can be compliant 1 second and fighting the next. Someone can be fighting and then compliant.
You might say the only predictability is unpredictability.
But reasonable police officers continue to assess and reevaluate. This is the critical decision-making policy, right, or model. You gather information, you assess the threat versus the risk. Do we have an authority to act? What are our goals and actions? Review and assess. Start over. Because this is not a singular cycle. This is a cycle that humans, as humans, we literally make millions of decisions in a day, right? Do I go this way? Do I go that way? Do I go up? Do I go down? I mean, we are constantly doing this. This is just human
Chat BTFO.
behavior. But in the policing context, you have to gather the information, assess the risk, assess the threat. Do I have authority to act? What are my goals and actions? Review and assess. And it's constantly rotating. At the precise moment that Mr. Floyd was laid on the ground, a reasonable police officer would know about those previous 17 minutes.
Figure out how
A
you
reasonable
guys
police
will
officer would know
recover.
about the struggle. He would reasonable police officer would consider the suspect's reactions to the previous use of force. A reasonable police officer would continue this process of reassessment. And a reasonable police officer would consider whether to use an additional force to overcome the suspect's level of resistance, right? So 9 minutes and 29 seconds.
I appreciate that. I do.
You got your
Jesus.
Thank you.
Not moving.
Mama.
Continuing to assess the risk and the threat. The first 29 seconds, 20 seconds, continued resistance is what a reasonable police officer would interpret that to be. Jesus.
And again, I think Eric Nelson is doing a very good job in nailing this second-degree murder thing. And I don't know that the arguments for third-degree murder are all that strong in general, but I think he's really hammering out the second-degree murder thing here very well with justification, so that's good. And again, for all of my criticisms of his things, they're less criticisms and more just stylistic disagreements. He is having to go through a lot of information. I mean, this is a long trial with tons of different testimony about really complicated issues. So, again, I think he's been doing a very good job, even if I disagree with some of his approaches. Giving closing arguments that last 3 hours is very bravo for that. Andrew War Snowboard says, always here to support the grift of the man that they call Fist of the North Star State. Please accept the gift of grift. Also, did you ever get those Shakopee Vietnamese donuts? No, not yet. Not yet. Okay, since I keep seeing this question in the chat, my gut tells me that Chauvin is not guilty on the murder charges, but is guilty on the manslaughter charges. It's not based on a legal analysis. I think both sides have made an adequate case for either a conviction or an acquittal. It's really up to the jury. Juries aren't predictable. And it really comes down to typically 1 to 2 jurors who have strong personalities in the jury room. Someone asked earlier, do I think the jury has already made up their mind? Yes, the jury made up their mind before walking into the jury room. The question is not whether or not they made up their mind. The question is anyone going to change their minds once they're in there? Because the way juries tend to work is you have 1 to 2, maybe 3 if you're really, really unfortunate, strong personality jurors, and then they will be working on most of the other jurors who are weaker personalities and more go with the flow types. That's just how it goes in a lot of jury rooms. So that's what's going to be there. And which ones you get as sort of the alphas of the jury room is going to depend on, that's going to determine the outcome of the case in a lot of cases. So that's why I'm not like making predictions on what's going on, because it's really, it's up to so many elements that we don't have any information about the types of jurors, how they're reacting to this stuff. So we'll see.
Jesus Christ, the kicking. A reasonable police officer would consider, should we elevate the use of force as we meet this threat? And that's precisely what these officers did. They discussed using the MRT, the hobble.
Oh, please, man.
There you go. And doing a lot of
Mama, I love you.
Are we calling for
I
EMS?
can't do nothing.
Yeah, EMS is on their way.
My face is gone.
Well, do you want to hop on at this point then?
I can't breathe, man. Please. Please let me stand. Please, man, I can't breathe.
They're discussing, should we use the hobble? Should we elevate our use of force? A reasonable officer would continue to evaluate whether the suspect is under the influence. Precisely what these officers did in 9 minutes, in this 9 minutes and 29 seconds.
The park's still sitting on the car there.
Look at my face, man.
I believe so. I found a pipe.
Get out of the car.
I ain't doing this real. Please,
Yeah, across the street, park's watching.
please,
2 other people with
please, I can't breathe. Please, man. Please. Mama,
a weed pipe on him. There might be
Mama,
something, so that might be like
I can't. I'm pissed.
Is that the
All right.
shaking of the eyes, right? Is PCP?
My knee, my neck,
Or the eyes like shaking
I'm
back and
through.
forth like that?
I'm through.
So reasonable police officers discuss the scene. The first clip,
I bet they threw that clip in there just for the one guy in the background's like, it's because you didn't listen. That guy's great.
they're talking about the 2 other people that are over at the car, right? What's going on here? What are we dealing with? Is this person under the influence of a controlled substance? These are the actions of a reasonable police officer. A reasonable police officer would rely on his training and experience. Call EMS. Possibility that a suspect who was struggling with us will begin to struggle again. You've heard this testimony from multiple police officers. The risk that the suspect would present to himself if he's not continued to be controlled, and the risk that the suspect presents to other officers or citizens if not continued to be controlled, if he's not continued to be controlled, right? These are things that all of the police officers have testified about. These are what a reasonable police officer should do. A reasonable police officer in this situation would call EMS. 2020, 11, 8/20/11. Within a minute of the struggle, EMS code 2 for a mouth injury, right? Because they are not observing life-threatening, a reasonable officer is not observing life-threatening injuries at this point. They just fought with the man for a minute. He continued to kick at them when they got him on the ground. They see he's got a mouth injury. We need EMS. So a reasonable police officer would evaluate the injuries of the suspect, compare words and actions, and respond by calling EMS. Non-emergency. But again, reasonable police officers evaluate, reevaluate. 2021, 8:21, 1 minute.
That argument about reasonable police officers reevaluating, that may come back to bite him on the negligence question, though.
And 24 seconds later, we need EMS here faster. Code 3. 3:30. We need him here faster. A reasonable police officer would take into consideration the anticipated time of a emergent response. You heard from Genevieve Hansen, there's a firehouse a few blocks away, and she would have expected EMS to be there within minutes. 3 minutes is what she said. A reasonable police officer, based on his training and experience, is going to have and take that into consideration. I put this person in a prone position on the ground. I'm holding them for my safety and their safety. I'm expecting someone to be here within 3 minutes to help this person. I have called for that help. A reasonable police officer will take into consideration, again, his training, his experience, right? Lieutenant Mercel talked about, and many people talked about, many of the officers talked about how it is not uncommon for suspects to feign or pretend to have a medical emergency to avoid being arrested. Unfortunately, that is the reality. Nobody likes to get arrested, and reasonable police officers know that. How many times does someone, oh, my heart hurts, or I'm having a medical emergency, insert whatever emergency, right?
Okay.
Simply because they don't want to go to jail. A reasonable police officer will
Does that
take
work? I'm getting old.
his
I can try the
training
heart thing.
into experience. And you heard Lieutenant Mercel specifically say that when someone says that they can't breathe, but they are talking, if they're talking, it means they're breathing, right? If they're talking, it means they're breathing. And again, compare that to the testimony of Dr. Chauvin, who told you that same thing. That is true. If you are talking, you are breathing. It doesn't mean effectively. And Dr. Chauvin described how even medical doctors have problems sometimes assessing the legitimacy of a patient's needs relevant to their respiratory processes, because they're saying, I can't breathe. And some doctors confuse it for just anxiety or this or that. So if medical doctors make these mistakes, Dr. Tobin told you it provides a false sense of security, right? Lieutenant Mercel told you that that is what is said among police officers. He's the trainer. So how many times do we hear an officer say, based on his training and experience, if you can breathe, you can talk. If you can talk, you can breathe. Excuse me. I counted 7.
I can't choke. I can't breathe. Please.
You're talking. Sit down.
Fine. My wrist.
Again, at that point, in hindsight of it, all the cops wish they would have just closed the
I know I
fucking
can't
door.
breathe. I can't breathe.
You're talking and oxygen. Not breathe.
I'm sick.
Relax.
I can't breathe.
You're doing fine. You're talking fine.
I can't breathe. I can't breathe. Please. I can't breathe, officer.
You're talking. A lot of
They
yelling.
will kill me. They will kill me, man.
Takes a heck of a lot of oxygen.
Come on, man.
Reasonable police officers, again, are trained and take into consideration A person's actions relevant to their words, their training, their experience. Takes a lot of oxygen to talk. Takes a lot of oxygen. You're breathing fine if you can talk.
Mind you, that
He's talking, so he's fine. Okay. We tried that for 10 minutes.
That's some bum ass shit, bro. Y'all know that. You guys think you're so deal on your egg, bro?
He's talking, he's fine.
Bro, he ain't
Okay. All right, we're done.
You circled
Okay,
him
we're
like
done.
Reasonable police officers will take into consideration their training and experience on excited delirium, and they will analyze it within the context of this case.
Go on one side. I just worry about the delirium or whatever.
I worry about the excited or delirium or whatever. That's why we have EMS coming. It's not just leave them here. It's we have EMS coming, and this is why we have EMS coming. Reasonable police officers, throughout the course of a control technique, will continue to assess the level of resistance. And remember what Lieutenant Johnny Mercil said. Simply because a person isn't kicking at you or punching at you or biting at you, it does not mean that you can't control them physically with your body weight. This is at 8:24. This is the point where Dr. Tobin testified that Mr. Floyd had an anoxic seizure, right? But we're not analyzing the use of force from the perspective of a doctor with 46 years of medical experience who had 150 hours of time to watch an event from multiple perspectives over and over and over and over again. It's a reasonable police officer standard. How would a reasonable police officer interpret this? Does a reasonable police officer even know what an anoxic seizure is? A reasonable police officer will interpret this as at least some form of minimal resistance.
I mean, that's a bit presumptuous on the reasonable resistance part, but I mean, or minimal resistance part. I don't know that if I go all the way there, but Nelson did say earlier it's not about his subjective experience; it's about a reasonable or his subjective perception and opinion. It's a reasonable police officer's opinion, which is true. It is reasonable police officer, but I don't know. I think that part is a problem because here you have in the video that he's playing here, and this I think might not have been a good clip, at least for me, because right there you've got another quote unquote reasonable person standing on the side of the road saying, look at his body language, just look at him, he's dying. And I don't know that that clip is what I want the jury to be hearing during my closing argument, because I don't know if I want them hearing someone else plainly observing what we know happened, right? Like Robert Nelson has this rough sort of position of talking to a jury about what Chauvin's expecting, but we know the outcome. Like we know that every time Floyd says, I'm dying, that he's right, that he is dying, that he does die from this. And Nelson has to basically argue that Chauvin either is trained to act indifferently towards the dying. This isn't a fair thing, but it's the reality of the argument. He's either got to act indifferently towards the dying, or he doesn't know that he's dying, so he's not actually as aware of the situation as we might want him to be. that's a tough place to make an argument from. He's doing a pretty good job of it, but I want to point out the difficulty of this argument, because all of the jury knows the spoiler on this story. Floyd died. He did. And he died during this encounter or just after, whatever it is. He died as a result of these events, whether they were the drugs, whether it was asphyxiation, whether it was an exploded heart, whatever it might have been. Everybody looking at this knows that he's dead. And so Nelson has to kind of overcome that. And it's a really difficult thing to do, because either the cop's not paying as much attention as the guy on the street, or the cop knows and is being indifferent towards a person who's imminently dying. And that's a weird place to be. I don't know. I wouldn't have included that particular clip because of that background audio to me. But again, he's the guy getting paid quite a bit of money to do this. So, his judgment's the only one that matters here.
Police officers, again, are continuing to monitor. They're expecting EMS to arrive.
Bro, but you're already off the ground. You're being at Walmart now. You can get him off the ground, bro. You can get him off the ground. You're being at Walmart now. He enjoying that. He enjoying that shit. He enjoying that shit. He's a fucking bum, bro. He enjoying that.
Especially, just real quick, when he's talking about how a reasonable police officer is going to be reconsidering and reevaluating constantly. Like, have they not noticed that his actions have changed dramatically, right? Like, he's saying, well, they're going to interpret his leg coming up a little bit, the seizure that the doctor talked about, as a minimal level of resistance. But he's no longer calling out. He's no longer yelling. I assume he's not struggling in the same way in his upper body, and his leg movements are pretty slight. Like, so that kind of undermines the argument for me that a reasonable officer is constantly reassessing and reevaluating, because it doesn't seem like they've done that in this clip. Again, I don't think these two clips are doing him any favors.
Non-deadly force is included. It includes, but it is not limited to, physically subduing, controlling, capturing, restraining, or physically managing a person. These are the policies of the Minneapolis Police Department. Reasonable police officers, again, continue to monitor. See if he's breathing.
I think he's passed out.
I think he's passed out.
Available if you could start for an assault at next door to 2313 Washington Street.
All right, so.
Yeah, I mean,
Not so far.
my knee might be a little scratched, but I'll survive it.
I think he's passing out, but he's breathing, right? This anoxic seizure occurs. Reasonable police officers are building and basing their decisions based on all of these factors coming in at multiple times, including the bystanders, right? Call them a crowd, call them onlookers, call them bystanders. It doesn't matter what term you use for the people that gather to watch what police do. Reasonable police officers are cognizant of and aware of their surroundings.
Again, it's a weird argument to be making when they're ignoring the change in Floyd. Will this be the outcome of the case? Stay tuned and find out. Who knows? But again, I would hesitate to make some of these arguments, especially juxtaposed with the video of him acting so dramatically different.
And before I really kind of start talking about the crowd in some limited detail, I have thought a lot during the course of this trial about the difference between perspective and perception. Perspective and perception are two distinct concepts. Perspective is the angle at which you see something. It's your perspective. Perception is how you interpret what it is that you see. I've thought about this a lot during the course of this trial because this situation here in the courtroom is incredibly unique, right? It's not the normal setup for a jury trial. So my perspective through the course of this trial, sitting in this chair, is that I cannot see 4 of the jurors. Very limited opportunity to observe the jurors. They probably can't see me either. Several of the jurors I have a very good view of. 4 of the jurors I don't, and obstructed views of others. My perspective sitting in this chair when witnesses, there's a camera blocking the head. So in order for me to see the witness, I have to roll all the way over to the other side. Then I have to look through the plexiglass that has these large reflecting lights. Right? Things block your perspective. Things can affect your perspective. But your perception is how you interpret what it is you see and what it is you experience. And that is our life, right? This is our experiences. These are the things that make us who we are. 3 people in this trial went to the same high school. Me, Darnella Frazier, and Chief Arredondo. We all went to the same high school, obviously at different times. My experience, Chief Arredondo's experience, Darnella Frazier's experience, all based on, we had the same perspective, sat in the same classrooms, saw the same chalkboards or whiteboards, the same perspective.
Whiteboards.
But our perception of our experiences there is going to be much different.
Were bigger and more successful than the other boards.
Ultimately, at the end of the case, when we're done with these arguments, the court will instruct you on how to deal with these biases and the perception issues. The court's final instructions will guide you to try to recognize your biases, recognize them, what we bring to the table, and analyze the evidence from the perspective of the evidence itself. So let's look at this incident on May 25th from the perspectives and perceptions of simply just 4 of the bystanders.
Whiteboards persisted by developing
Charles
farming early
McMillan,
on.
61 years old, 3rd grade in education, grew up in the South. He described himself as a curious guy. He likes to know what's going on in his neighborhood, so he stops and he checks things out, right? His perspective, he's the first one who's dealing with these guys. He has more information because he sees the entirety of the situation. But his perception of the event is affected by his life's experiences. At the end of the night, ultimately what he said to Officer Chauvin was, "I hope you get home safely," because that's what he says to police officers every night.
Can you advise the fire department if they're still with you, they need to go to 36 Miss Park to assist with the
But I feel respect. That's one person's opinion. But no, I gotta get him. We gotta control this guy because he's a sizable guy. Yeah, and I tried to get in the car. Looks like he's probably on something. But I'm just saying, but no, I got nothing bad to say about this because you respect me, I'm gonna keep respecting you. Right. You have a good night. You go home safe with your family. Don't keep you the same.
Darnella Frazier. She's a 17-year-old high school student who, upon seeing the restraint of George Floyd, her response was to pull out the cell phone and start recording, and then subsequently upload it to
WorldStarHipHop.com.
right?
Damn. Thought it was WorldStar.
Her perception of the event and her perspective of the event. She's looking, she didn't even know that Officers Lane and King were there because her perspective was blocked by the squad car. But her perception, her response to the situation was to record it, and that's perfectly fine. But she began her recording at 8:20 and 51 seconds. Donald Williams, He's a 33-year-old professional mixed martial artist who arrived at 8:22 and 39. He
how
spent the day
professional?
fishing with his son, stopping for a drink when he became aware of the incident. He described his view of this based upon his perception as a mixed martial artist, right? He has a set of experiences that caused him to react in a different way. What he perceived was happening was that Mr. Floyd was being choked with a blood choke. I think we're past this at this point. The paramedic reached in, touched the carotid artery. To have a person rendered unconscious through a choke requires the blockage of both carotid arteries. This was not a neck restraint. This was not a chokehold. He was upset. And that, again, is okay because his perception affected what he was seeing. Genevieve Hansen, right? 27-year-old female firefighter for the city of Minneapolis.
Oh, God.
She testified that when she walked into the scene, she described the crowd as upset. She said, I walked into an upset crowd. She said that the other voices distracted me from getting the officer's attention. And she testified, again, based on her perspective, that Officer Chauvin appeared to have his hand in his pocket. She observed what she believed to be blood on the from Mr. Floyd's face being pressed into the pavement. She observed fluid coming from Mr. Floyd's body that she presumed to be urine. She testified that nobody ever told her that EMS or an ambulance was on the way. She asked about, when I asked her about the response time she would have expected, 3 minutes. When I told her that paramedics had been called about 5 minutes prior to her arriving on scene, no way.
He annihilated her in that cross-exam, by the way. He annihilated her. He made her look like an absolute fool who had no idea what she was talking about. It was great. She was a terrible witness.
Perception is 3 minutes. But when you look at the things that Miss Hansen saw, whether it be from her perspective or her perception, there can always be more to the story. The blood coming from Mr. Floyd's nose was why they called EMS in the first place. You've seen the pictures. He injured his nose during the struggle, or his face during the struggle in the squad car. The fluid that she described as potentially being urine, we know that that's fluid coming from the undercarriage of the squad car.
I cannot breathe.
Officer Chauvin specifically told her an ambulance was coming when she first came on scene.
Don't come over here. Don't come over here.
Off of the sidewalk.
Yeah, we need you to keep some distance. Yeah, the ambulance coming.
Yeah, they have no duty to let this dumpy random person in street clothes come up and help them. They don't know anything about her. They don't know her credentials. I'm a medic. Yeah, sure you are. No, they did the right thing there.
Yep, we got an ambulance coming. The computer-aided dispatch
Goodyear, the tire of oppression.
reports clearly show what time EMS was called. So Genevieve Hansen has a perspective and a perception. And what she observed was not consistent with the actual evidence. But remember, we don't look at this incident from the perspective of a bystander. We do not look at this incident from the perspective of the people who were upset by it. We look at it from the perspective of a reasonable police officer. A reasonable police officer, when confronted with these bystanders, would know everything that had occurred up to that point. 20 minutes, 25 minutes, 30 minutes. They know all of that information. The bystanders do not. A reasonable police officer would understand that his actions were actually being recorded. Take the bystanders out of it. Officers wear cameras for a very specific reason, to record their actions, so they know they're being recorded. Officers are aware of the placement of city cameras. You're in a high retail, you've got gas stations, restaurants, convenience store, high surveillance. Right? Reasonable police officers know this. They would know if citizens take out their cell phones and start filming. This is the point at 8:20 and 49 seconds when Miss Fraser starts recording. Reasonable police officers are aware when they're using force that sometimes what they are doing does not look good to the general public. A reasonable police officer will hear the frustration growing. Right? A reasonable police officer will hear the increase in the volume of the voices. A reasonable police officer will hear the name calling, right? Chump, whatever names are being called. They'll hear the cursing. They'll hear this, and they'll take that into their consideration. A reasonable police officer will rely on his recent training. Excuse me. A reasonable police officer will hear I'll come back to the training. A reasonable police officer will hear what the crowd is saying. He will compare his actions to what they are saying, and he will determine, I know I'm being recorded, right? I know I'm being recorded. They're saying that I'm doing something that's awful looking. Am I doing this?
Right.
He is human, bro.
His nose is
What I'm saying, you can put him in the car. That's some bum ass shit. For 10 minutes. That's some bum ass shit, bro. That's some bum ass shit, bro. Y'all know that. You don't gotta sit there with your knee on his neck, bro. He's talking. Bro, he ain't crying, bro. You circulate like in a jiu-jitsu move, bro. You trapping his breathing right there, bro. Like, you don't think that what it is, bro? You don't think nobody understands that shit right
not
there,
a jiu-jitsu
bro?
move.
At the academy, bro. That's some bullshit, bro. Right, that's bullshit, bro. That's bullshit, bro. You fucking stopping his breathing right there, bro.
That's a shit jitsu move.
He's talking. Bro, but you can get him off the ground. You being a bum right now. You can get him off the ground, bro.
Being a
you can
bum.
get him off the ground. You being a bum right now. He enjoying that. He enjoying that shit. He enjoying that shit. He a fucking bum, bro. He enjoying that shit right now, bro. You could have fucking put him in the car by now, bro. He's not resisting arrest or nothing.
You can see Officer Chauvin's.
Now, hot take, I support the shooting of the bro guy. Like, that guy's really fucking annoying. Cheers to the chat. I'll drink the rest of this gin, then I'll add a little whiskey to it for the likes. Thank you. Not your bro, bruh. Oh, he did say you a bum. That's kind of funny. Calling people bums is funny. God. Gin is just distilled depression.
Body language tells us a lot, right? That's what we just heard. Looking down, looking up, looking around, looking down, looking over, looking around. He's comparing a reasonable police officer. He's doing what a reasonable police officer would do. He's comparing his actions, his own actions, in response to what the crowd is saying.
Now, again, this is that problematic part of the argument, because once it shifts away from murder to negligence, I feel like there's a change in how Chauvin acted. There's certainly a change in how Floyd acted. And if the jury thinks that same way, that could be a problem. That's a big if. It's a big if. You never know. And again, we're looking at the arguments here. So it's not really a criticism. It's just, I'm not so sure I would go with this tack on as far as he's gone. I don't know if he makes a distinct transition here. We'll see if he takes his HRTs.
A reasonable police officer, again, will rely on his training. 2020, March of 2020, tactics of a crowd. Never underestimate a crowd's potential. Most crowds are compliant. Crowds are very dynamic creatures and can change rapidly. A crowd may contain elements of several types of groups. Now, I acknowledge that this is in dealing with massive crowds, protests and things of that nature. These are the tactics, but you never underestimate a crowd's potential, because a reasonable police officer has to be aware and alert to his surroundings. A reasonable police officer will consider his department's policies on crisis. And what is defined as a crisis? Crisis: an event or situation where an individual's safety and health are threatened by behavioral challenges to include mental illness, developmental disabilities, substance abuse, or overwhelming stressors. A crisis can involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds the individual's current resources and coping mechanisms, and may include unusual stress in his or her life that renders him or her unable to function as he or she normally would. The crisis may not necessarily result in an upward trajectory or intensity, culminating in thoughts or acts that are possibly dangerous to himself, herself, or others. Right?
See, Nelson's problem here is he's not reading super chats.
Recognizing that the crowd is in crisis. That all of these things, the members, the bystanders, the citizens, whatever you want to call them, they are in crisis. So a reasonable police officer considers his department's training. What are these potential signs of aggression that I may be confronted with? Somebody standing tall, somebody red in their face,
someone wearing red face. People are commenting in the chat, so let me talk about this. The reasonable police officer being said over and over and over. Apparently, Barnes on Viva and Barnes suggested that this is a tactic that he said was risky, but could pay off in the eyes of the jury. Trying to associate Chauvin with a reasonable police officer almost psychosomatically is what someone was saying in the live chat. I don't think psychosomatic's the right word, but you know what? I just drank gin, so get over it. But you get the idea. You get the idea that he's trying to juxtapose reasonable police officer and Derek Chauvin into the same thing, so that when the jury thinks about him, they think of him as reasonable. However, I think the risk of that, and Barnes probably acknowledged this as well, because I think he said it was risky. I didn't watch them, by the way. You should watch Viva and Barnes. It's a great show. I like both of them, respect both of their legal analysis as well as, their other opinions. I haven't watched their particular show on this, but definitely check them out. The risk, of course, is that if you tell them over and over that Chauvin's a reasonable police officer, and then they determine that he acted unreasonably, then he acted outside of what a reasonable police officer would do. They're constantly thinking reasonable police officer, and then they get to dead black man. It could backfire. That's the kind of risk you're facing there. So, but that's what he's doing. I think that's a pretty safe sort of estimation of what he's doing, is that he's trying to juxtapose Chauvin's actions as reasonable in the mind of the jury automatically. And it is a good play in that respect. I still think it's being overdone a little bit. This is just so long.
Raised voice, heavy breathing, tense muscles, pacing, right? This is from the crisis intervention training. This is what Kerr Yang testified to. These are signs that police officers are trained to look for in a crisis as potential signs of aggression. How do you respond to those? You appear confident in your actions. You stay calm. You maintain space. You speak slowly and softly, and you avoid staring and eye contact. Again, these are things that Kerr Yang discussed in terms of how to deal with a crisis. As this crowd grew more and more upset or deeper into crisis, a very critical thing happens at a very precise moment. And I cannot, in my opinion, understate the importance of this moment, the critical moment in this case. If you recall from Dr. Tobin's testimony, nobody disagreed, that Mr. Floyd took his last breath at 8:25:16. 8:25:16. What is happening at the very precise moment that Mr. Floyd takes his last breath? You're taking one piece of evidence and you're comparing it against the rest. This moment, 8:25:16, as Mr. Floyd is taking his last breath.
Get off him now! What the fuck? He got mace. He got mace. He cannot breathe. Get over here. No, first of all.
Bro, look, bro, you can check on him. He's not responsive right now.
Look at him.
He's not responsive right now. He's not responsive right now. He's not responsive.
Three things happen. Mr. Floyd takes his last breath. You see Officer Chauvin's reaction to the crowd is to pull his mace and shake it. He's threatening the use of force as is permitted by the Minneapolis Police Department policy. And Genevieve Hansen walks in at that time from behind him, startling him.
Yeah, she's dumb
All
as
of
shit,
these
by the
facts and circumstances simultaneously occur at a critical moment. And that changed Officer Chauvin's perception of what was happening.
Oh
After this
boy.
point, the crowd grows louder.
We got
and
2
louder,
hours of this
right?
left. Holy
And
shit.
At this point now, Mr. Floyd has taken his last breath, and the question is the rendering of medical aid.
The Big Red Bear says, quote, "You watch for aggression, you handcuff the subject, you get them on the ground, you place your knee on their neck so they restrict airflow and slowly kill the subject. This is what a reasonable police officer does." Yeah, that's the risk of the argument. It really is.
When do we stop CPR according to the Minneapolis Police Department's policy? When it's not safe.
Yeah,
heard-
that's the problem. When do we stop CPRs when it's not safe? The jury right now is going, in my opinion, could be, I don't know. I'm not their mind reader, but you never started CPR. This is the problem with that manslaughter charge creeping in behind the rest of the charges.
Lieutenant Mercel talk about this, and you also heard Nicole McKenzie talk about this. Consider Nicole McKenzie's testimony. As far as the reasonable police officer, which would include Nicole McKenzie, she discussed at length the difficulty of performing CPR in what she would describe as, or she did describe as, a hostile environment. You miss signs. Agonal breathing can be confused for effective breathing. As she testified, people in the area can affect the decision to treat a subject at the scene. She described how it is incredibly difficult to perform EMS efforts in a loud crowd, difficult to focus when you don't feel safe, makes it more difficult to assess a patient, makes it more likely that you can miss signs that a patient is experiencing something. So the distraction, she said, can actually do harm to a patient. When we're talking about this critical decision-making model, right? As Lieutenant Mercel said, he testified, sometimes you have to take into consideration whether it is worth the risk to remove the handcuffs and render medical aid, because it's unpredictable. right? All of this information is coming at a reasonable officer. The reasonable police officer standard can also be extended to Officer Chang, right? What is his perception of the crowd? You heard him testify, but you can also look at what was he doing during this time?
Jawanda. What was that?
I think I'm gonna one of the store guys.
Okay, let's stay put. We'll figure it out, right?
Right? You've got Officer Chang pacing, turning around 360 degrees, right? His attention is focused on what's happening with the crowd. But he also has another job, right? Reasonable police officers and how they interact with the crowd is a consideration. You can also take into consideration the reactions of Shawanda Hill and Maurice Hall.
Damn, he still won't get in the car. Just sit down, dude. They gotta push him in this car. Look, he's fighting to get out. That's total resistance. What is he doing? Now he going to jail. All he had to do was not a nigga going to jail. Look, they still fighting him. Hey. Oh man, what is he doing? Oh, they going all around.
I like these two. They're funny.
And their reactions to what's happening. But also consider the paramedics, right? The paramedics. They did the load and go, right? As Derek Smith testified, he got out of the ambulance. He checked all four corners to gauge what was happening and determined, in his words, that it was an unwelcoming environment. And he told his partner they needed to move to a different location, a more safe and secure location. Remember Nicole McKenzie's testimony too. As unreasonable as it sounds, paramedics get attacked too. We have all of these different opinions in terms of the use of force.
I can't even say
right?
the joke because
all
of
the
stupid
opinions
YouTube.
of Seth Stoughton.
I only attack
Cody
paramedics
Steiger,
who try and
Barry
give me that
Broad,
MMR
Zimmerman, Arredondo, David Pluger, Lieutenant Mercel, and they all reach very different conclusions about when the force became unreasonable. All you have to know about Barry Broad is what he was talking about is this physically managing any person. His opinion was you can use non-deadly force to physically manage a person. It's all within the model of the MPD decision-making model. I found the most interesting person to be relevant to the use of force, Lieutenant Johnny Mercel, considering that he is Derek Chauvin's actual use of force trainer. So the best glimpse that we're going to get into the training of a Minneapolis police officer comes from the trainer who conducts the trainings. He's conducted hundreds of trainings over the years. He corrected the state at certain times in terms of how strike charts don't apply to restraint techniques. He said the knee on the neck is not an unauthorized move, and it can be utilized in certain circumstances. He described using a knee on the neck and back and stated that it can be there for an extended period of time, depending on the level of resistance you get. He said that once the suspect is handcuffed, it does not necessarily mean that it is time to move your leg, because when people are handcuffed, they can thrash around and continue to be dangerous to themselves and others. He talked about the ground defense program because it's safer for both the suspect and the officer. He talked about ground defense as a form of using your weight to control a subject without, and therefore replacing the need to punch or strike them. He said there's no strict techniques. You need to be fluid and adapt to the circumstances. That he personally trains officers.
There aren't
to
closed
put a
captions
over
on
the
this
shoulder
live stream, guys.
Up to the base of the neck, and he described this maneuver as routinely trained by the Minneapolis Police Department. He testified that there are circumstances that an officer would need to use his weight to continue to control a subject. He recognized the concept of awful but lawful, right? Sometimes the use of force is just not that attractive. He's experienced himself arresting people who have claimed to have a medical emergency. He explained how one way people can resist is through their words. He described how someone resisting can become passive and then become resistant again, and vice versa. He discussed how officers are trained not just to focus on the subject, but also the bystanders. He trains officers that if you're fighting with a suspect and that person then becomes compliant, it is a legitimate consideration for the continued use of force to control a subject. That if a subject overpowers more than one officer at a time, that is a legitimate consideration in the continuation of the use of force. He talked about substance abuse and how that officers are trained, right? I understand that superhuman strength is not a real phenomenon.
Okay, if you're bored and I'm bored, the jury's bored. And that's a problem with the length of this argument.
There are no Supermen or Spider-Men, right? But officers are specifically trained that someone under the influence...
I'm not increasing the speed because I want us to get the experience that the jury is getting. Mind you, they just listened to a couple hours of prosecution talk as well. Then they had a break. Then he gets going. I mean, who?
Influence of certain types of controlled substances exhibit this behavior. They become stronger than they normally would. We've all heard the anecdotal stories of the pregnant mom lifting the car off of someone, right? It's not literally describing a superhero. It's simply describing that someone is exhibiting a greater strength. And the Minneapolis Police Department specifically trains that. He trains on neck restraints. Minneapolis Police Department has a specific written policy on the use of neck restraints, and it was permitted, even though this wasn't a neck restraint or a chokehold. He talked about how you need to cut off the blood supply for a neck restraint to both sides of the neck. He talked about how someone whose heart rate is beating faster, they go unconscious quicker, less than 10 seconds. He described the human factors of force. That is, how does
the lunch
use
break
of
is
force
55
affect the
minutes away.
officer himself, his cognition, his abilities, his mental and physical state. He agreed that not using the MRT is a form of de-escalation. He described that sometimes you have to use your body weight to control a subject until the scene is code 4. He said that Minneapolis will train officers that under certain circumstances, an officer can hold a person in the prone position until the scene is safe. And he's done it himself at times. You have to take into consideration the presence of bystanders, where officers are located, and the environment that they're in. Lieutenant Mercil agreed that there are circumstances where I talked about this a little earlier ago, where you have to make a decision, is it worth the risk to take the handcuffs off to perform medical aid? He said there are circumstances where you wouldn't put someone in a recovery position, depending upon the safety of people, including the crowd, while awaiting EMS. He described how crowds can make situations chaotic. He said, simply because a person is not actively resisting, that does not mean that you cannot use force. Right? Doesn't mean that you cannot use force. Simply because someone isn't stabbing you or punching you or shooting at you, it doesn't mean that you can't use force. And that is specifically in the Minneapolis Police Department policy on the non-deadly use of force that we've looked at a couple of times. The use of force is an incredibly difficult analysis. You can't limit it to 9 minutes and 29 seconds.
I mean, you can.
It started 17 minutes before that 9 minutes and 29 seconds.
Doesn't mean it's right, but you can certainly do it.
All of this information has to be taken, you have to look at it from the totality of the circumstances. You have to look at it from the reasonable police officer standard. You have to take into account that officers are human beings capable of making mistakes in highly stressful situations. In this case, the totality of the circumstances that were known to a reasonable police officer in the precise moment the force was used demonstrates that this was an authorized use of force, as unattractive as it may be. And this is reasonable doubt. Steiger talked about being on the panel, right? They have 5 officers on a panel to assess whether uses of force are reasonable. Sometimes it's 4-1, sometimes it's 3-2, sometimes it's 5-0, because the reasonableness of the use of force is not an easy thing to consider. I know, again, I'm sorry, I'm long-winded. There are a couple of other things I need to talk about very briefly. I promise I'll be as brief as I can before I get to the cause of death.
He's
First
got
is that
like an
concept
hour and a
of
half
intent.
of talking left.
As the state showed you, with respect to counts 1 and 2, you have to address Mr. Chauvin's intent. Pay careful attention again to the instructions. Words have meaning. Intentionally or intentional means that the defendant either has the purpose to do the thing or cause the result specified, or believes that the act, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal and that are set forth after the word intentionally, intentional. It's the same, you'll see a very similar instruction. You'll see this very similar instruction twice. Intent. Did Officer Chauvin intentionally apply unlawful force? That's what you're being asked to decide. Did he purposefully apply unlawful force to another person? In count 2, you have to decide, did he purposely perform an act? Did he intentionally perform an act that was eminently dangerous?
Totality of the circumstances.
What considerations do you have at your disposal? What pieces of evidence do you have? I'm going to try to go through these quickly. What evidence is there? What evidence is inconsistent with intent? Some facts and circumstances that are important for you to decide in terms of his intent is within the.
I know he has to hit this. It's really boring for me because I'm pretty much already on board with his argument. So I'm trying not to be biased. Look at the wide boy cop in this reflection. The way he looks here. Whoa, Chungus cop. Shut up, where my donuts at? Sorry.
In the context of aiding and abetting other people. First, officers know that they are being videotaped. They know they're being videotaped by themselves. They know they're being videotaped by bystanders. They know they're being surveilled by the Minneapolis Police Department milestone camera, right? They know these things. Do you do something purposefully that you know is an unlawful use of force when you have 4 body-worn cameras immediately in the area where you have multiple civilians videotaping you, where you know your actions are being reviewed through a city-owned camera, where there are surveillance cameras, do people do things intentionally and purposefully when they know they're being watched? Remember, Officer Lane offered to have, when they were putting Mr. Floyd into the squad car, he said, I'll sit with you. I'll put the window down. I'll turn on the air conditioner.
Man, please. I'm just claustrophobic. That's it.
Well, you're still going in the car.
Anything sharp on you?
I won't do nothing to hurt y'all.
Anything sharp?
No, sir.
Now you want to get home or nothing?
Nothing. I don't have nothing. Why y'all doing me like that, Mr. Officer? Please crack it through me for me and stuff, man. I am claustrophobic for real, Mr. Officer.
You got him?
Could you please crack it for me, please?
Yes, I'm
Remember my
cracking.
name. Stay with me, man.
I will.
Please stay with me, man. Thank you. God, man. I didn't know all this was gonna happen, man. Please, man. I just want my hands, please. I don't want none of y'all, man. Nothing.
You got him?
Inside in your pocket real quick.
I'm listening. And I understand that as people do stuff,
All right, he's good. This comes with it. There's nothing worth it.
Okay.
Grab a seat.
Because that was my
I'll roll the windows down, okay?
Please, man. Please,
Get in the
don't
car!
take a seat.
Ah,
Go
just
in.
get in the car!
No, you're not. I gotta go in.
Take a seat.
Grab a seat, man.
Mine, I don't believe me, Mr. Officer.
Take a seat.
I'm not that kind of guy. I'm not that kind of guy, man.
Take a seat.
Y'all, I'm gonna die here.
Take a seat.
I'm gonna die, man.
You need to take a seat right now.
And I just had COVID, man. I don't want to do to that.
Okay, I'll roll the windows
No.
down.
You're not gonna get COVID in the car. Just get in the
Man.
car. Get in the
I'm not that kind
car.
of guy.
I'll roll the windows down and
Please,
you put
man.
your legs in, all right? I'll
Y'all
put the air on.
stop. Look at that. Look at that.
Not even
Look
listening.
at it. Look at it.
All right. I'll roll the window down 3 times. I'll turn on the air conditioning. Is that evidence of intent to apply unlawful force?
I think that's a good use of video clips, by the way. Anytime showing Floyd being annoying or resisting is actually a good thing. I think they should do that a lot more, even though I hate it. Big Red Bear. When is Chauvin's DA going to get charged for attacking the jury? This closing argument is violence. His argument that Floyd was doing some heard resisting is dumb. The resisting happening there was the resistance to breathing.
Officer Chauvin confirms that Mr. Floyd is under arrest.
Take a seat.
Please, man. Please listen to me.
Is he going to jail?
Listen to me.
He's under arrest right now for forgery.
I tell you.
Can we figure out what's going on?
For what?
Take him out.
For what? Please, man.
Officer Chauvin made a decision not to use higher levels of force when he would have been authorized to do that, including punches, kicks, elbows, right? All of these tools were available to Officer Chauvin. That is not.
Are any of us asking why he didn't start punching and kicking him? Like at this point, like, oh my God, get in the car. Stuff him in there with your foot and close the door.
Not an intent to purposefully use unlawful force. They call for EMS within 1 minute of putting him on the ground. They step it up within another minute and a half. He believes that Officer Chauvin believes that Mr. Floyd's ability to speak means he can breathe, and they say it repeatedly, remember? Excuse me. They tell him to relax.
You're the arrest guy.
All right. Oh my God.
So now you go to
I
jail.
can't believe this.
Officer Chauvin is never swearing at him. He's not calling him names. All of this stuff that we've already talked about, and I don't need to go through this again. All of this stuff that we've talked about throughout the entirety of this circumstance does not reflect an intent to purposefully, intentionally commit an unlawful use of force. All of the evidence shows that Mr. Chauvin thought he was following his training. He was, in fact, following his training. He was following Minneapolis Police Department policies. He was trained this way. It all demonstrates a lack of intent. There is absolutely no evidence that Officer Chauvin intentionally, purposefully applied unlawful force.
This video seems edited.
Officer Chauvin is also refocusing
The hell was
other
that?
officers, telling them they need to do things to pay attention to Mr. Floyd.
Let's get him on.
Should I put his stuff in the car? No, we need to get him in the ambulance. Let's refocus, right? Officer Chauvin had no intent to purposefully use, or he did not purposefully use unlawful force. These are officers doing their job in a highly stressful situation. According to their training, according to the policies of the Minneapolis Police Department, and it's tragic. It's tragic. They go to the hospital. They perform CPR. They call their supervisors. Was this an eminently dangerous act? Was putting Mr. Floyd an eminently dangerous act?
Okay, he's moving on to murder 3.
Position. Consider just the basic prone position. People sleep in the prone position. People suntan in the prone position. People get massages in the prone position. The prone position in and of itself is not an inherently dangerous act. It is not an...
I mean, I don't know what kind of massages you're getting, but mine don't involve 3 dudes.
Inherently dangerous act. A prone position during restraint is not an inherently dangerous act. It is routinely trained and used by the Minneapolis Police Department. The studies show, right? The Canadian studies that were referenced by Dr. Fowler. 1,269 cases, use of force, 1 death of a person not in the prone position. Right? These are people, they're looking at people in the prone position. 4,828 consecutive force events. No significant clinical effects on the subject's physiology. Right? We can look at all of the other studies trying to determine this question is putting a subject in the prone position, even with officers on top, even with weight on top of the person, is that inherently dangerous? And the research says no. The practical experience says says no. The prone position, when applied through a use of force, is not an eminently dangerous act because there is no evidence to support the notion that it is highly likely, that's the standard, highly likely to cause death. There's reasonable doubt about that.
And yet some states specifically disallow it because they have determined the opposite, for example. But, I mean, it doesn't play in here, but it's an interesting sort of question about about what the stats say, right?
So let's talk about the cause of death. And again, I'm sorry to be long-winded, but I have to address the cause of death. Because the state neglected to read perhaps one of the most important sentences from the instruction, and why you must read the instruction carefully. Yes, the defendant is criminally liable for all of the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes. If such intervening causes were the natural result of the defendant's act. Okay? So if the intervening causes were the natural consequences of the defendant's acts, he's liable. So think about it in this example. Police officer arrests somebody. He puts that person on a hot August afternoon in the back seat of a squad car, rolls up the window, turns on the heat, and leaves the person in there, right? Person dies of a heat stroke. Officer put him in there and is responsible for the natural consequences of his actions. But consider the situation where police officer arrests someone, they're compliant, they go into the backseat of the squad car, they're sitting in the backseat of the squad car, and they have a heart attack. They have a pulmonary embolism. They have a brain aneurysm. Something happens to that person that was not the natural consequence of being arrested. It was just a physiological something that happened to that individual. The officer is not liable because it's not in the natural course of events. And it's not the result, the natural result of the defendant's act. Right? So again, read the entire instruction. The significance of this instruction, again, is that it goes through all.
Chris Nemo says, "Screw you, angry Baneling. I won't do what you told me. Now I'm going to give Susan my shekels just out of spite." Rude. But I don't know. I like super chats, so I'm good with it.
All of the three charges. You have to be convinced that the defendant's actions caused the death of Mr. Floyd. And throughout the course of this trial, the state has tried and called numerous witnesses to try to convince you that asphyxiation is the singular cause of death. The singular cause of death. And why is that? It's because actions that happened before Mr. Floyd was arrested that had nothing to do with Officer Chauvin's activities are not the natural consequences of the defendant's actions. You have to focus on the consequence of the defendant's acts. And so the state has tried to convince you beyond a reasonable doubt that the stress of being arrested and the adrenaline produced as a result of Mr. Floyd's physical resistance played no role. This is what they have to try to convince you. There's no role of that physical exertion played no role in this death.
I mean, that's not
They're trying to
entirely
convince
true.
you beyond a reasonable doubt that Mr. Floyd's heart disease played no role in this case. The state must try to convince you beyond a reasonable.
This is an inaccurate portrayal of it, which is interesting because they don't actually have to prove that the heart disease played no role in the death. They just have to prove that the role that Chauvin played made him liable. It's a different sort of perspective, but you know, I guess it's closing argument, so you get to kind of say some interesting stuff.
Reasonable doubt that Mr. Floyd's history of hypertension played absolutely no role in the cause of Mr. Floyd's death. The state must convince you beyond a reasonable doubt that Mr. Floyd was not experiencing excited delirium that contributed to the cause of his death. The state has to convince you beyond a reasonable doubt that Mr. Floyd's paraganglioma was not contributing to the cause of death. The state must convince you beyond a reasonable doubt that Mr. Floyd's toxicology played no role in his death. Right? The state would have to convince you beyond a reasonable doubt that a combination of these pre-existing issues did not contribute to Mr. Floyd's death. That is why the state has brought in expert after expert after expert to testify that the singular cause of death here is asphyxiation. Because if Mr. Floyd was asphyxiated as a result of the police restraint, he is liable for the natural consequences of that restraint, of his actions. But if any of these other factors come into it, if any of these other factors were substantial contributing factors of Mr. Floyd's death, because they were not the natural result of the restraint. If a person has drugs in their system and that drug causes an overdose in the context of the police restraint, it's not the natural consequence of the restraint, it's the natural consequence of the deceased's actions.
I'm assuming they
So the
address this
state
on
has
rebuttal
called
because he's not accurately
experts.
retelling what the
Really
legal
five.
standard is there. So that's
I'll include
interesting.
Dr. Baker. The state first called Dr. Tobin, a pulmonologist. Dr. Tobin said that you need to apply common sense to the evaluation of the medical testimony. He testified that Mr. Floyd died exclusively from positional asphyxia, coronary artery disease, hypertension, controlled substances. They played absolutely no role in the death, according to Dr. Tobin. The state called Dr. Eisenschmidt, a toxicologist, to explain to you that Mr. Floyd's toxicological levels were somehow more consistent with a DWI case than a whole bunch of other cases that may or may not have involved an overdose, right? Remember the ratio where you said, well, no, these are cases, they may have died of something else. They may have died of a gunshot wound, but they had fentanyl in their system. So he gave you these strange statistics, but essentially attempting to try to convince you that these levels are insignificant. People drive their cars around, right? And that therefore the drugs played no role in the death of Mr. Floyd. Third, the state called Dr. Smock, an emergency room physician, right, to explain to you that Mr. Floyd was not experiencing any symptoms of excited delirium. And that coronary artery disease, hypertension, controlled substances, none of that comes into play. He called Dr. Thomas, a pathologist, to testify how she interpreted what Dr. Baker meant. How she concluded that Dr. Baker simply said that the cardiopulmonary arrest is the basic way everybody dies. And she interpreted the reason why Dr. Baker put those factors on his autopsy or on the death certificate were merely for statistical purposes. You put stuff, the CDC requires us to put that stuff on there. And it was an asphyxial death. Controlled substances played no role. Hypertension played no role. Coronary artery disease played no role. They did call Dr. Baker. And we'll talk about Dr. Baker in a minute. And finally, the state called Dr. Rich, a cardiologist who concluded that despite a 90% narrowing of the right coronary artery and a 75% narrowing in the left anterior descending artery, despite an enlarged heart and a history of hypertension, that Mr. Floyd had a strong heart, and that none of those pre-existing and coexisting conditions in any way contributed to the death of Mr. Floyd. I submit to you that the testimonies of Dr. Tobin, Eisenschmidt, Schmock, Thomas, and Rich, it flies in the absolute face of reason and common sense.
I get what he's doing there, but look at the uphill battle he's fighting, and this is what I've been saying for a while. You're having to go against medical experts testifying credibly that Chauvin is the cause of death for Floyd. Over and over and over again. Here he is. Now, I mean, he's using it with some inflection, with a little bit of pizzazz to make it seem, well, man, they say that all this stuff, it had nothing to do with it. I get how he's saying it, but listen to what he's actually having to say. they're saying that the enlarged or the reduced blood flow or the blocked artery or whatever, it had nothing to do with it. They're saying he had a strong heart. Like, what he has to overcome here is huge. And he is doing well on the closing argument aspect of this. But the fact that they had to listen to these medical experts days ago, tell them all of this with a high degree of confidence. And from what I saw, the defense didn't have the best answers to those medical experts. That's a really tough place to be for the defense. And I think Nelson knows it. He's got to minimize their good testimony, not refute it by providing better testimony. And that's not where you want to be in a battle of experts. Paul Durfee, no, murder 2 is the felony murder. Murder 3 is creating an imminently dangerous environment, creating a situation imminently danger to others and acting with a malicious mind and reckless disregard for the life of someone else.
It's astounding, especially when you consider the actual findings of Dr. Baker, right? Because Dr. Baker is the only person who actually performed the autopsy in this case. He's the only person who performed the actual autopsy. He told you that he specifically avoided watching the video because he didn't want to bias or influence his autopsy. He specifically testified that there was no evidence of asphyxia. There were no evidence of petechial hemorrhaging. There was no bruising to the neck or back above the skin, under the skin, or into the subcutaneous muscles of the neck and back. And he would expect to see those things in a case like this. There was no finding that pressure was applied to the point of Mr. Beck to cause these injuries. There were no injuries to the structures of his neck, and that when he finally did review the video, it didn't appear that the placement of the knee affected the structures of the neck because Mr. Floyd could lift up his head, turn his head, move it around. He saw no fractures to the structures of the neck, including the hyoid bone. There were no soft tissue injuries to the sides of Mr. Floyd's neck. There was no hemorrhaging or injury to the hypopharynx. No evidence of life-threatening injury to the neck or spinal column of Mr. Floyd.
This is really good, again, for the murder 2. How can you show unreasonable force if there's no injuries? And I like this line of argument from Nelson here. To be clear, my last commentary about the 5 medical experts or whatever, that wasn't criticizing Nelson. That was just talking about what he's facing in this case. I'm not saying he did a bad job. He has a hard set of facts to overcome. This is a good way to go about it. I really like this approach. Again, I haven't heard anything about the negligence side of this case yet. I'm wondering if he's going to get to it. But so far, he's doing really well on the murder 2. And my personal problem is I agree that the murder 2 is a bad charge, so I kind of just want to get past it. But, that's a me problem.
There was pulmonary edema, which is the swelling of the lungs, which could be caused by the resuscitative efforts or fentanyl. There's no evidence of hypoxic changes to the brain. There's no evidence of any brain injury consistent with an asphyxia death. He found a paraganglioma, and he said it was an incidental finding. He said his heart was enlarged. Mr. Floyd's heart was enlarged, right? Dr. Baker, Dr. Thomas, Dr. Rich, and Dr. Fowler all agreed. He found narrowing of the right coronary artery, 90% narrowing. He found 75% narrowing of the left anterior descending artery. He's the person who did he sent out the toxicology samples. Fentanyl level at 11 nanograms per milliliter. Methamphetamine at 0.19 per millimeter. all of these findings that are ultimately relied upon by all of these other experts were done by Dr. Baker. He determined that the manner of death was a homicide, right? Homicide, homicide, homicide. But read the definition again of the medical definition of homicide. It is to be emphasized that the classification of homicide for the purposes of the death certificate is a neutral term and neither indicates nor implies criminal intent, which remains a determination of within the province of the legal processes. Right? The fact that he found this a homicide is a medical term.
Let's be clear, though. A medical term, that means that the death was caused by another person. The person causing that death would be Derek Chauvin. This is this is the tough nature of that argument. Right now, he's quibbling over whether homicide shows intent. And no, I don't think Chauvin intended to kill Floyd. If Chauvin intended to kill Floyd, there were plenty of ways he could do it intentionally. I don't think that's the issue here. But he's still stuck with the he's trying to argue that Chauvin's not the cause of death, that this other stuff was, and he's relying on the medical examiner and the medical experts, and the medical examiner's ultimate outcome is that it was a man-caused death by someone other than Floyd. And so that's a harsh reality Nelson has to deal with here. He's doing a good job of it. I'm not criticizing him. I'm just saying that's a tough thing to overcome. Bad Vibe says both defense and prosecution have an issue. The police have used many non-lethal techniques, technologies, removed after a few negative outcomes. We have limited data and police deal with medical anomalies because number of law. Ace of Spades says, hey, Nick, you missed my first super chat. Just say it at the end. I ain't mad, though. Doing electronics homework while listening. You better watch all of this. I want to solve the suffer tonight. We're not watching through to the end tonight. We're going to stop actually really, really soon because we've still got 30 minutes till the break. And I'm about done with this one. Bad Vibe says, no studies, no real data. Therefore, or no real data before or after their implementation or removal. Until we remove stupid laws, do real study on non-lethal tech, we will always see cases like this. And Great Bates says, could the defense argue George Floyd would have lived if there were no narcotics in him? They would have had to get an expert to testify to that. I mean, I guess they can make the argument. Seeing as the cops followed policies and used techniques that taught to them that were approved, taught to them by their department, also take my money. Look, the one thing I will do is definitely take your money, for sure. However, that being said, yeah, I mean, they're basically, he's trying to make that argument right now that that something else would have was the cause of death here, other than the knee. But it's a tough one, man, because again, you've got all of these experts testifying that this is the issue, that this is the cause of death. And the cause of death was not everything else, and he's having to say that while trying to overcome it.
Dr. Fowler talked about the undetermined manner. Could not be determined is a classification.
And just to be clear, difficult facts to overcome doesn't mean that Chauvin is guilty either. There are lots of cases where people are not guilty, but the fact set is very difficult. So, don't take that as a statement about Chauvin. It's not. It's just the truth.
Used when the information pointing to one manner of death is no more compelling than one or more other competing manners of death in or through consideration of all available information. Dr. Baker found the immediate cause of death and the other contributing factors. Cardiopulmonary arrest complicating law enforcement, subdual, neck restraint, and neck compression. Other contributing factors are arteriosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use. The term complicated in this is important. because Dr. Baker was able to give you what he said his actual intent was, right? Dr. Thomas speculated about what she thought Dr. Baker meant. Dr. Baker was able to tell you what he meant. He defined complicating as an intervention that occurred. An intervention occurred and there was an untoward outcome on the heels of that intervention. And he gave you a specific example. He described a person having a hip surgery and a blood clot comes loose, and that blood clot causes a death. The hip surgery didn't cause the death. The death was caused by the blood clot that complicated the surgery. So as I understand his testimony, what Dr. Baker was saying was that there was an unexpected result. The death of Mr. Floyd occurred during an event where you would not generally expect such a complication, subdual and restraint. He specifically testified, Dr. Baker specifically testified that if he put it on the death certificate, it played a role in the death. If something is insignificant to death, you don't put it on the death certificate. So Dr. Baker's conclusions that Mr. Floyd's arteriosclerotic and hypertensive disease played a role in the death of Mr. Floyd. Dr. Baker concluded that Mr. Floyd's fentanyl intoxication played a role. Dr. Baker concluded that Mr. Floyd's recent methamphetamine use played a role. Right? Dr. Baker described that this death of Mr. Floyd was a multifactorial process. A multifactorial process is how he defined it. No single factor, one over the other, played any more of a role resulting in Mr. Floyd's death. He said his heart simply couldn't handle it within the context of the subdual and restraint. Apparently, the state, as they just argued, wants you to believe what you see. And they did not like Dr. Baker's conclusions.
Believe what you see is a pretty common sense, reasonable argument. Again, he's a very good lawyer. He's doing a very good job. He has a very long presentation with a lot to say, and I'm picking out particular things and criticizing them. That's one that I wouldn't do. They want you to believe what you see. Well, I mean, that's pretty hard to disbelieve what you see.
And you can see the process Dr. Baker talked about when he had several meetings, right? This happened in March. Excuse me, happened in May, June, July. By August, talk to a pulmonologist, talk to an emergency room doctor, not within my area of expertise, talk to a cardiologist, right? His findings didn't support the notion that what you see is what you should believe. And so the state did that. They went and hired Dr. Chauvin, right?
So they went and hired all these people to come in and do it. Again, weird approach.
Pulmonologist. Now, despite all of the information that Dr. Baker has concluded or found during the actual autopsy, Dr. Chauvin concluded emphatically that Mr. Floyd's death was the result of positional asphyxia, right? The pressure of the asphalt, pressure of the weight of the officers, positions, all of this resulted in hypoxia, low oxygen to the brain. Mr. Floyd was asphyxiated through positional asphyxia. Remember at the beginning of my remarks, I asked you to perform an honest assessment of all of the evidence in the case. And I'm going to submit to you that with no other witness should this be more carefully analyzed. I want to illustrate two brief things that Dr. Chauvin testified about, and I want to illustrate how I think that these demonstrate a bias, because you still have to consider an expert witness in the context of bias. I'm going to call it the finger and knuckle testimony and the toe lifting testimony. You may remember this slide, right? That this slide shows George Floyd pushing his fingers against the street to lift his shoulder off the street. That he was pushing his knuckles against the tire. Right? He described what he interpreted this was basically Mr. Floyd trying to push himself up onto his left side to free the right lung to help him breathe. Look at the timestamp of the photos taken from the body-worn camera here. They were taken at 8:19:35, 15 seconds after Mr. Floyd was placed on the ground. Yet Dr. Chauvin also explained that Mr. Floyd went on to breathe for an additional 5 minutes and 51 seconds until he took his last breath at 8:25. He neglects the fact that at this point, this is the point that we just saw, when Mr. Floyd is taken out of the car and he is actually in the side recovery position for about the first 2 minutes of this 9 minutes and 29 seconds.
Not moving.
Mama! Mama!
Yeah,
Mama!
lay out.
Mama!
One of the front couches
Mama!
on my right side bed.
Mama! Mama!
You're the rest guy.
All right. All right. Oh my God.
Sorry, go to jail.
I can't believe this. I can't believe this. I can't believe this. I can't believe this, man. Mama, I love you. Reese, I love you.
You got Mama?
Just my kids, I love you. I'm dead.
My side, it's listed, it's labeled. Says Mama. It's in the
I can't
top.
breathe for nothing, man. It's cold blooded, man.
Sorry, I tried to dodge that sneeze. It didn't work.
Mama, I love you. I can't do nothing.
Yeah, EMS is on their way.
My face is gone. I can't breathe, man. Please.
All right.
Please let me stay in.
No.
Please, man, I can't breathe.
Get up on the sidewalk, please. One side or the other, please.
My face getting bad.
Here, should we get his legs up?
Oh my God.
Nope, just leave him.
Oh
Just
my
leave him.
God.
Just leave him. Yep, just leave him.
All right.
I'm dead.
The park's still sitting on the car. They were.
Look at my face, man.
How can you take, this illustrates how you can take a single nanosecond of time in this arrest. You can have this testimony that he's pushing his body up to try to breathe.
This is good stuff, by the way.
But when you look at the evidence compared to the rest of the evidence, what do you really see? You see a person who is on his side, being held in the side recovery position, whose hand is touching the ground and the tire at times.
I mean, to be
You
fair, he
cannot
also
take
did have a knee on
single
his neck
isolated
at the
frame
time.
and reach any conclusions, because much like the use of force, cause of death has to be considered within the totality of the circumstances. And then you may remember this testimony. This is Officer Chauvin's foot off the ground, and he described how at this precise moment Officer Chauvin was applying 91.5 pounds of pressure to the neck of Mr. Floyd. So let's look at this time in the context of the other evidence.
His whole nose.
Bro, but why you just sit there? He ain't doing
Kill me.
How long y'all gotta hold him down?
This is why you don't do drugs, kids.
It ain't about drugs, bro. Y'all understand that?
Did anybody even see the toe come up off the ground? I mean, was it a half a second, a quarter of a second? Right? But
Who's
when you take a single
Who's the based crowd man saying this is why you don't do drugs, kids?
incident, a frame, a single frame, and you add the drama, and you make all of the assumptions, right? Officer Chauvin's body weight, Mr. Floyd's EELV. He's the only person who calculated the EELV based upon the presumptions of health, based upon studies, based upon theory.
Who's Officer Tao?
All of this information, you can put this into a single frame, but you have to analyze the evidence in the broader context. You can also see during the clip that Officer Chauvin actually is sort of adjusted forward and touches this car, right? You can make a lot of informed decisions about how is he shifted. If I'm shifting my weight this way, majority of my weight.
I love defendants because you know the defendant is listening to the attorney going, yeah, it's a good point. Because again, it's really easy to break to show how complicated your day is. But when you're going through it, your brain sorts through most of the complicated aspects and gets rid of a whole lot of them, the overwhelming majority of them, and simplifies your day for you. So it's kind of funny to think about like Chauvin sitting there going, yeah, that could be what I was thinking.
It is shifting on my left foot. If I'm this way, it's on my right foot.
We're going to go to we're going to go up to the break and then we're going to stop. There's about 10, 11 minutes left until the break. We'll do super chats and then I'm going to stop for the night. Tomorrow is going to be a live stream. I'm going to have a live stream at 6 p.m. tomorrow. 6 p.m. There will be a live stream with Vox Day. We're going to do an update on the Patreon suit for Owen Benjamin, the arbitration stuff that's going on there with whatever he can say. I'm not sure exactly how long that'll go. And then we'll have a regular show tomorrow night as well.
You watch this video and you can see the dynamic shifting. And you can see the placement of the toes, right? The toe tucked under helps an officer maintain his weight or helps any person maintain their weight. But a toe flopped over to the side, it's a little harder to balance. You cannot take a single frame and draw conclusions. You have to look at the totality. And remember, he said he spent 150 hours analyzing this tape. His entire testimony is filled with theory, speculation, assumption. Do not let yourselves be misled by a single still frame image. Put the evidence in its proper context. We have to talk about the toxicology. Again, we're not suggesting that this was an overdose death, right? It's a multifactorial process, as Dr. Baker said. So we have to look.
If it's not an overdose death and it's multi-factor and one of those factors is Derek Chauvin, then he's the cause. If without him you wouldn't have a death, you've got a real problem here if any of his actions were unjustified. Now, I think, again, they've made a good argument on the justification, but that being said, this isn't the best approach, in my opinion.
Look at what role does the toxicology play in this case. And you need, because again, we had Dr. Eisenschmidt who testified that he found that the levels of fentanyl and methamphetamine were more consistent with this DUI population. But what do we know about the actual toxicology? there were 11 nanograms per milliliter of fentanyl and 0.19 nanograms of methamphetamine. Those are the principal two findings. And additionally, what we know is that the byproduct of methamphetamine, which is amphetamine, was not reported at the levels. Doesn't mean it wasn't technically there, but it was not reported. So it's below threshold reporting values, which signifies that the methamphetamine use was recent. Hence, in Dr. Baker's death certificate, he included the recent methamphetamine use because there was no amphetamine. The history of Mr. Floyd's use of controlled substances, it is significant. It's not a character problem. Millions of Americans suffer from the opioid crisis, right? I mean, it is a true crisis that this country is facing. But it is significant to understand the history, not just as much as the long-term history, but his long-term history provides us with insight on how his body physically reacts to methamphetamine or opioid use, I should say, opioid use within the context of a law enforcement encounter. We know from the testimony of Courtney Ross that Mr. Floyd struggled. We know he had been using controlled substances habitually for some time. We know that on May 6th of 2019, during an encounter with the police, Mr. Floyd ingested some controlled substances, said they were Percocets. He was startled by the police, like he was in this case. Officer drew his gun in that case too. And that resulted in a blood pressure of 216/160. I mean, that's not just high. That is skyrocketing high. We know from Ms. Ross that in March of 2020, they purchased some pills that were supposed to be Percocets, an opioid. But they were clearly knockoffs. She described that. They were clearly knockoffs. She described how those pills made her feel. They kept her up all night, right? The introduction of the methamphetamine. We know from Ms. Ross that in March of 2020, Mr. Floyd was seen for a drug overdose. She described how he felt in that instance. She said his whole body hurt. His stomach hurt. We know, based on, again, from Ms. Ross, that he was clean and sober for some time while they were in quarantine. We know that Ms. Ross again described taking about a week before a similar pill to the one that they had back in March. Kept her up again all night, right? She said she felt like she was going to die. We know, again, from Ms. Ross, that those pills were purchased from Maurice Hall. She described going to a hotel. While Mr. Floyd went into the hotel, she was on the phone with him. She heard Maurice Hall's voice. We know Mr. Floyd was with Maurice Hall on May 25th, 2020. We heard from the store clerk, Christopher Martin. He described Mr. Floyd as being high. His responses were delayed, right? He may have been, standing around. He may have been standing up. He may have been able to have communications. But Mr. Martin clearly described him as being high. We heard from Shawanda Hill that when they got back into the car, right, they had a conversation for a few minutes, and suddenly Mr. Floyd fell asleep. All of these things become important. That he had trouble. They had trouble waking him up. She called her daughter for a ride because they couldn't wake Mr. Floyd up. They couldn't.
He just misgendered Floyd. Execute him. Guilty as charged.
We heard how Mr. Martin described Mr. Floyd when he went back to the car, and how he was, no, he wasn't speaking, right? But he kept putting his head back, and shaking his head. We know from Peter Chang's body-worn camera that Maurice Hall also described that Mr. Floyd was dozing off.
He got tendency because he was falling asleep a little bit, and then when he woke up, they was up at the door.
Right? We know that whether Mr. Floyd was chewing gum while he was in the store, we can also see he was eating a banana.
Oh my goodness.
Right? He bought a banana.
Okay. There it is. Did he just litter with the banana peel? Well, now he's guilty too.
So we know when we look at this picture, right, there's something in Mr. Floyd's mouth. Is it gum? Is it banana? Is it drugs? Nobody knows, right? But regardless of whether it's drugs, bananas, or gum in this incident, we know that there were pills in the car, right? We know that there were drugs in the car. We know those pills were later tested to be a combination of methamphetamine and fentanyl. That's what was in Mr. Floyd's system. It's relevant because it's what was in his system. These are the pills that were found.
Cars are so gross. Cars are universally
We
gross.
know at some point Mr. Floyd was handcuffed. His hands were behind his back. It would have been physically impossible to put anything in his mouth at that point. And we know that in the squad car, 320 were pills. We know those pills were analyzed. We know those pills consisted of fentanyl and methamphetamine. We know that Mr. Floyd's salivary DNA was found on those pills.
Okay. Good.
How much fentanyl does it take to kill? This is from the Minneapolis Police Department's training. Approximately 2 to 3 milligrams. Smaller than a penny. This is from the squad car. You can look at these pictures closely during the course of your evidence. There is a video of Mr. Floyd when Mr. Floyd is being subdued by and restrained by the police. Mr. Maurice Hall reaches into his bag. He's looking through the windows. We watch it. And then he throws something. Right? We know that Mr. Floyd had drugs in his mouth. We know that some percentage of that would have been consumed and absorbed into his system. We don't know how much he took before, right? We don't know when he took an earlier dose in relation, because fentanyl had actually started to metabolize in his, so fentanyl was longer before. For the medical experts to minimize the timing and the amount of illicit drugs that were found in Mr. Floyd's bloodstream, it is just simply incredible to me. It is incredible to me.
I mean, it is their job.
Every single doctor testified that relevant to the absence of signs of fentanyl overdose weren't present because he was alert, he was talking. But it ignores what Shawanda Hill and Maurice Hall says, right? That he was all of a sudden asleep and difficult to wake up. It ignores the fact that,
I mean, to be fair, in the video, he wasn't asleep or difficult to wake up until after he had been under Chauvin for a while. So, I mean, I kind of get it. I kind of get it. And this is another one of those hard facts where he's stuck. He's stuck fighting against the fact that the medical experts testified to something very specific.
the combination of these two drugs, methamphetamine is a powerful stimulant. Fentanyl is a powerful sedative. They use it for surgeries. Every single doctor dismissed outright. No, nothing about this case. Well, it was only 0.19 grams, nanograms per milliliter. It's such a small amount of methamphetamine in his system. It's a vasoconstrictor. It causes the heart's arteries to constrict even tighter. Doesn't matter. Every single doctor just brushed it aside, said it would have no effect. I ask, would any of those doctors prescribe illicit methamphetamine to their patients? Would they give it to their children? Would they give it to their elderly parents with a 90% blockage of the coronary artery, the right coronary artery? I guarantee you the answer is no. Dr.
Importantly, he didn't ask that question for a very good reason.
Rich is the only one who said, I would never recommend to my patients that they take any amount of illicit methamphetamine. It is preposterous. That it is a preposterous notion that this did not come into play here.
Half-hour break for lunch. I don't want to interrupt your argument, but
Thank you. I apologize. It's
members of the jury, 30 minutes for lunch, please. Thank you.
Okay. Yeah, the judge had to poop. That's pretty clear right there. Look at him. Look at him. That man ate a breakfast burrito. He is out of this courtroom ASAP. Okay. We'll finish this up tomorrow during the later show, during the normal 11 p.m. show. We'll finish up the last minutes of Chauvin. I don't think we're going to do the prosecution tomorrow because there's other stuff I want to talk about. And I don't know if I can do this for that much time in a row. We'll see. We'll see. Trump Willis is my name, says Kermit. Look, the officer had reason to shoot Floyd because we all know how dangerous banana peels. I mean, come on, Mario Kart proves this. Not guilty, I say, and my friend Mario Money Diddy knows this firsthand. Okay. An ace of spades earlier, I missed this one, says, I hate it when you talk in your Kermit voice. Why can't you talk like a normal human? Also in Kermit voice. Hey there, guys. Nick Rekieta of Rekieta Law. I love my Lord and Savior Legal Eagle, so subscribe to him. Hashtag Kick Vic. No. No. There you go. There you go. Pump Fake says this chat is full of sheep. Reported, and I will not be back. Later, homie. Okay. Always good. Thanks, guys. Thanks for getting me reported. Don't go to school tomorrow. Some of you are cool. Okay. Let's do the rest of the chats. Man, I didn't even really talk about my trip to Georgia or show you guys any pictures or anything, or talk about the very, very funny soldier I met from North Carolina who is hilarious. So we'll probably talk about some of that tomorrow on the show. Let me read these chats and then we'll wrap it up for tonight. I'm not going to do Twitch tonight because I'm still really tired from traveling. I have a bunch of headache right now from listening to Eric Nelson for a long time, and I just need a little bit of sleep. So I'm gonna not do Twitch tonight. Tonight was gonna be movie night. Tomorrow's video game night, and then Wednesday will be My Cousin Vinny. So get ready for My Cousin Vinny on Wednesday. It'll be a fun time. Mario Carter 13 says, based on information provided by the FBI, the government understands that it is common for persons discussing criminal activity online to refer to such activity as occurring in Minecraft to conceal the true nature of the activity. And Soye says, I snitched. Yeah, apparently they figured it out. If you say, kill yourself in Minecraft, you scrub, you mean literally. So they figured that out. Kermit the Frog says, hey, Nick, you stink. You smell like shit. Take a shower. Soap and water. Eddie says, when I found out that my comments and chat are all hidden, I thought YouTube got me. But it turns out I'm only banned from your channel. But I never spammed, and I'm not even that spicy. Can I get unbanned, please? Come on, it's been over a month. Yeah, Eddie, email me with your name. I don't think anybody's banned in the channel right now. I'll check. I can check this right now. Community. Oh, there are a couple. Hey, there you are, Eddie. Why are you banned? Why is this guy banned? Some of the people that were banned are probably what? Some of the who the fuck is are probably mistakes. So we'll fix it. I didn't know anybody was banned at all. Some of them were probably legitimate, but there you go, Eddie. You should be unbanned. Also, I think Batgoat got banned, but that seems like an accident as well. So that should be fixed. Night of Hope. So, by the way, if any of you guys ever get banned permanently, please let me know. That's not what we normally do. Sometimes when some like weirdo crazy person is spamming a bunch in the chat, a moderator might try and click the 3 dots, but if the chat's moving a lot from spam, they could accidentally grab someone else. So please, if you get banned, let me know, because it was probably unintentional. Night of Hope says, someone should have told that brony that Monica exists in real life and that her ass is very not married. There was still a chance for him to have a real marriage with a real horse. He could have been arms deep in love with her before you could say yeehaw. Gross. Bad Dragonite says, if I were the prosecutor, I'd be like, oh yeah, Nelson, you know who made the great chocolate chip cookies? George Floyd's mom, who he called out for when he was brutally killed. Night of Hope says, I think this guy drones too much. He never sounds like he's driving at a point. He's really good when he's getting at something important. If he was surgically taking apart each element and explaining why they don't apply, that would be way more compelling. Yeah, I think he got wrapped up in the length of his argument, because it's going a long time, man. Really long argument. Gummy says, drink some whiskey so you can criticize him more. A pissed off Nick is always better. Linda Marie, I think I missed this, says, take a shot of water when Nelson/prosecutor say reasonable officer in closing. Then no matter what the verdict is, we will be hydrated. I listened to it all, and you were right. It did pick up towards the tail end. Could Minnesota pass an anti-riot law similar to Florida's ASAP? I mean, maybe. They won't. Icon, I already drank whiskey and gin for the 1K likes. Where were we? There we go. Night of Hope says, one of the things I kind of think is BS is the idea that there was a huge threatening mob observing the situation, which made the use of force more necessary somehow. Getting up would have made the mob less angry anyway. Doesn't make logical sense to me. Buck Rogers says the officers do refer to the checklist and the excited delirium later in their body cam footage. Mario Carter 13 says, a reasonable police officer knows that white officers and Asian officers have to team up for them to have any chance of competing with the sheer size of a black man. Night of Hope says, couple more questions. One, they objected and sustained to a question about a general person surviving the use of force. Is that a rule in all of the trials? I'm not sure what you're talking about. I'm guessing during the prosecution, which we weren't watching today. Two, couldn't they have had actors demonstrate the use of force in the courtroom to show it wasn't lethal? They might find that to be prejudicial. I don't know. They would have had to ask the judge for permission to bring in actors. Dread Clown says, so does every lawyer have a boilerplate metaphor to explain the burden of proof to people who couldn't get out of jury duty? Probably. Does the prosecution ever go, oh, the cookie metaphor? I hate the cookie metaphor. Likely. Night of Hope says, that clip is contradicting the idea that he said they had Floyd in a blood choke. Bro said you're stopping his breathing 3 times. Also, one person said he's not moving or speaking. So he was ignoring what they were saying also. Bad argumentation here. Knight says, hey, I appreciate you trying to get through this tonight, though, buddy. I'm glad to have you go through this long form and take questions and stuff. I feel like this is a lot more educational with the chats and interaction. Good show. Hey, thank you. St. Floyd says, yo, Nix, Isa be watching yo stream from the afterlife, and Isa be wondering how D courts be treatings me. Isa was just trying to get me a couple of blunts for D smoking, and Isa aided D drugs. Isa be kicking it with D pedos dat Kyle's made into good commies. So that was from St. Floyd. Interesting dialect. There, Angry Baneling says, have some Indian shekels that have been converted to American shekels, Nikki. Also, we're doing a face-off and coming to America stream on Twitch today, right? Finally, looking forward to it, fam. Yeah, you go for it. Master Blaster says, got a bottle of Whistle Pig on vacation. Just want to say thanks for the recommendation. Oh, glad to make it. Hope you enjoy it. Mario Carter 13 says, got the book on male chauvinism just in time. I got called a chauvinist on Twitter today. An angry, drunk chauvinist. And I was like, okay, I mean, I guess. I feel like I'm a bad chauvinist, though. Russell Hall says, so Gail Cord Schuler is U.S. president now? What the fuck? Yes. Russell Hall says, honestly, I would 100% vote for Gail over Biden. Not only does she have better leave of her faculties, she's just less of a deranged piece of shit. I agree. Ninebreaker 2 says, forget looking at someone as innocent. It's hard for you to look at anyone with that nose. Rude. Ike of Pike says, Chauvin is killing some creepers in Minecraft. Chief Beef says, he kind of quirky, though. Mario Carter 13 says, Chenk, it's got to be reasonable, right? Of course. Lil Meme says, wonder if Floyd didn't die like he did, how long Chauvin planned on sitting on his neck for? It's a good question. It's a good question. Polyfrog64 says, Nick, they're going to riot no matter what. They could put this cop on a pike outside the courthouse. They would riot in celebration. Banana Republic. Yeah, I think so. Kinotoshi says, all cops are F slurs. Whoa. Mario, pissed off, says, Banana Ricada Law. Mr. Seiko K, thank you for the donation. Tina says, Nick shopping and arresting people are not the same. Yes, they are. They're the exact same thing. Classical Positioning says, all expletive jurors must expletive hang. Caleb Hughes says, I get the excessive use of reasonable officer being annoying, but it's a great cognitive tool to focus the jury's mind on the point he's making for days to come in deliberation. Maybe. V's Flat Desk Pepsi says, when will Floyd get found guilty on all charges? I don't think he's gonna, personally. Al Sharpton's Taxes says, I thought the state's medical witnesses were all over the place. I thought Tobin's testimony on forces acting on the body were not credible, and the state's medical examiner disagreed with him. Lil Meme says, dead guy says I can't breathe. Mr. Zeus, welcome to lawyer status. Thank you. Also says, could Mr. Nelson have addressed the question of systemic racism or calls for police reform in the closing arguments, even though it wasn't part of the trial? He could have. I don't know if it would have benefited the case at all. You have a lot of leeway on closing argument. Polyfrog64 says, Nick, there was a suspect a few years back who had an OD. Firefighter shows up. Cops uncuff him, and he killed the firefighter. Cop shot and killed him. There you go. Yeah, that's always the danger of someone who's overdosing is you don't know what they're on and what their reaction's going to be to being brought back. Kyra says, no head of state tonight. Please pick tomorrow or another night. Lol, any other night. I'm not doing it tonight, so that's good. Super Iron Bob says, Nick, new hot take, then offers utterly tepid take. Ash B says, this is not for you, Nick, but the Night Owls in chat buy Dogecoin and Safe Moon. Polyfrog64 says, the bro guy is Donald Williams. He was photographed looting, smashing squad cars, and he's a Black Panther. Found his Facebook and matched his green Nikes and his sweatshirt. He's a thug rioter. Isn't he also the MMA guy? Mr. Zeus says, Nick, will you do a collab with Viva and Barnes and Mr. Grueller? Like I said, love Viva and Barnes. Happy to collab with them anytime. I've had both of them on this channel, and I've been with both of them on, I've been with Viva on Eric Nelson's channel, or Eric Hunley's channel. Not Eric Nelson, Eric Hunley's channel. I don't know that I've been with Barnes on any other channel, but I'm happy to, like both of those guys. Mr. Grueller, I'm just kind of learning about and would happily have him on for a show or go on his show. Either way, he seems to be really covering this trial in depth, and he seems to be a good dude. Mim Moko says double masking is a cure for butterface. True. Polyfrog64 says Donald Williams also has the same hat on. Donald Williams. Chris Nemo says, maybe I'm just too dumb to get the arguments, but Nelson is really pushing me towards viewing this as a murder. Mim Moko says, Tom, do you sue the feds or the perpetrator? You sue the perpetrator. Andrew War Snowboard says, who do you prefer, Susan or Twitch Dear Leader? Neither. I prefer in Minecraft. Mr. Zeus says, Nick, do you think Judge Cahill's strong criticism of Maxine Waters' comments was appropriate, or do you think he went too far? I think it was fine, but I think it's a little bit too much bluster and hype. I mean, if he thought they were so bad, just declare a mistrial and get it over with. Mim Moko says, who pays the key tam? The feds or the perpetrator? The perp pays it, and then you get a portion of whatever they collect. As Cybertaz says, did they, or you for that matter, watch Floyd's 2019 arrest where he acts the exact same way, calling for his mama and acting institutionalized? I didn't watch it. I hear they played a portion of it during the trial. I know they had some restrictions on what could be played. Mr. Zeus says, Cybertaz and Ricada Law, actually, they were able to show the 2019 video, but the judge limited the scope under which the jury could consider it. So there you go. Architect of Fate says, get Ty on soon to ask him about his new cane and what it does. Do it, Nikki, do it. I'm about 2 hours behind, so have fun. Mim Moko says, headed to bed. Nelson is winning by putting the knee of boredom on the jury. Please read to yourself my email on Quitam. Please respond to me on your thoughts. Amateur Ant says, this was just a snuggle struggle gone wrong. Polyfrog64 says, spoiler alert, the judge went off on Maxine Waters, said her comments will likely win them an appeal. At least she did finally did something useful, Lamau. I didn't hear him say that they'll likely win on appeal. I heard him say it could get a mistrial on appeal. But again, if he thought they were so bad, he should declare the mistrial. He should do it. Clumsy K says his logic is mediocre because he's addressing a jury. That's a fair point. Lil Meme says, can't get over, was he alive before the knee? Yes, and after, no. Aspie says, Drex will be out this week. I'll prep the Vegemite. Oh, mate. Mr. Zeus says, Nick, do you think Maxine Waters intentionally made her comments over the weekend to affect an appeal or a new trial in order to drag out this issue through her re-election campaign? No, Maxine Waters is just an idiot. Never attribute to malice that which can be adequately explained by incompetence. Maxine Waters is just a moron. Big Bubba Chief says, hey, Nick just arrived. Was wondering what your thoughts were on the defense closing with the video of Floyd's seizure. I understand the point they were making, but the visual is just so damning. I haven't gotten there yet, so I don't know. Sorry. Bad Vibe says, here's an interesting question I would have asked. Would the police limiting his activity, would it have slowed the overdose? Interesting. Mattster333 says, shout out from Hutchinson, Minnesota. Hey, I answered you in the chat, but shout back to you. So jealous of your Buffalo Wild Wings. I wish we had one here. Keep on keeping on, man. Josh Rowe says, as a pharmacist, you would be surprised how many MDs prescribes uppers and downers together. Fentanyl is no effing joke. Mechanically, George OD due to drugs and horrible cardiovascular health. Bad Vibe says, in Kermit voice, I can only count to 4. Little Meme says, I love memes. This case, not so much. And Fo Chung Esquire says, spoiler, Floyd dies. That's it. Oh my gosh. You know, Buffalo Wild Wings is awful until you don't have anything like it. If you knew how bad the restaurant situation was here in the Wilmer, Minnesota area, Ashby, you would want a Buffalo Wild Wings too. Thank you guys for hanging out tonight. We're wrapping up the show. I got to get some shut-eye. So do you guys. There's going to be, more videos and some live streaming tomorrow. We'll see you guys there. Hope you enjoyed this one. Have a good night. Until next time. Peace. Peace. Oh, wait, I gotta turn the gain down. It's way up. That music would have blown your ears out. Okay. There we go. All right, guys. Peace. Peace. Follow me on Locals. Check me out on Odyssey.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we